start by reading out a statement.
Yes.
This hearing is in the matter of case CA-010-2021 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan Sawalehi, and Justice Lord Angus Glennie. The hearing is being held by way of video conference. Any orders or directions made during or after the course of this hearing will be issued by the registry here in Dubai on the judge's instructions. The applicant is represented by Holman Fenwick William Middle East LLP. Lead counsel is Sophia Hurst. The respondent is represented by MB Kemp LLB. Lead counsel is Michael Patchett Joyce. Thank you.
Okay, Ms. Hurst and Mr. Patchett Joyce.
Thank
we
you.
are ready to hear you.
Thank you.
Shala.
Yes, Chief Justice.
Call me Zaki, not Tun Zaki. Just
Yes,
Zaki.
sir.
Justice Zaki. Okay.
Yes, sir. Will do. Thank you.
The Tun is a title that's meant to be used in Malaysia. Okay. Yes, please, Ms. Hurst.
Chief Justice.
Oh, you're the appellant. Okay, sorry.
Your Honours, yes, I was. Perhaps I can explain that in just a moment, but may I begin by, I think, what must be the customary greeting on a Zoom virtual meeting where we're all in different time zones, and that is good day, Chief Justice and Your Honours. Having said that by way of total introduction, Ms. Al-Gaib was correct in that my learned friend, Miss Sophia Hurst, represents the claimant in this matter, and I represent the defendant in this matter. But for present purposes, the roles are reversed in that I must make my case first, because I am seeking to set aside the default judgment which was entered into, which was entered against my client back in September 2020. So although Ms. Al-Gaib was absolutely correct in terms of identifying who the respective counsel act on behalf of, I'm going to go first if that's convenient. And I think that's probably what my learned friend was expecting in any event.
It is
Mr. Joyce, Mr. Patchett
Yes, indeed, Chief Justice.
There are two issues here. One, basically setting aside the judgment, but one is on the basis that it was not properly served, not correctly served, because the judge had relied on the previous judgment of this court. The other way of looking at it is, if the defendant, your client, has what is the term used? What is the term used?
Reasonable prospects.
Yes, reasonable prospects of succeeding. Then we can also decide on that, which means that strictly speaking, we can ignore the issue of whether it was served within the jurisdiction or properly served, whatever it is. But because your client has a good defense or potentially good defense, then the appeal, the appeal can be allowed. Would you agree with me there, Mr. Patchett?
Well, Chief Justice, there are two issues, but in our submission, one has to look at them in a little bit more detail for present purposes, because the first issue goes to whether the default judgment must be set aside. In other words, the application of the mandatory provisions of the rules of the DIFC courts. And that is our principal argument. Then there are, of course, reasonable prospects, which is the alternative. And of course, we pursued both lines in seeking permission to appeal, which was granted. Now, my learned friend says, well, it was only on the first rather than the second. But of course, that doesn't really matter for present purposes, because if we succeed on our first and primary argument, namely that the default judgment must be set aside as a matter of the mandatory application of the rules of the DIFC courts, then of course what happens is the default judgment is indeed set aside, and we would then, I think, apply to amend the defence that stands, and matters would then proceed in ordinary course. That's certainly how I saw it, but and therefore we do focus on the mandatory aspect, which brings in the bank med consideration, which His Honour, His Excellency Judge Ali Al-Madani was concerned should be brought before the Court of Appeal in the DIFC courts, and of course this is a convenient opportunity to do so. So far as reasonable prospects are concerned, we say we do have reasonable prospects. We point to the whole range of matters that we place before the court, and which I'll come to in the submissions. But those would really be picked up in the amended defence once we've set aside the default judgment. So we're really taking it in steps, and the first step must be to set aside the default judgment.
Okay, yes, please proceed.
Chief Justice, thank you so much.
Justice Glennie was something to say, I believe. Angus, you have something?
You're on mute. You're on mute. I don't. Your Honour, can you hear me? You're on mute.
You're on mute. Press the button, the microphone button.
I think he's aware of that. It's finding the button that's the challenge. Maybe on the top, there's a cursor line on the top. There's a red button which says leave. Don't press that, please. But 2 buttons in, there should be a microphone, and yours probably has a slash across it.
Can you hear me now?
We can indeed, Your Honour.
I just lost it altogether. I couldn't find a mute button.
Yes.
It disappeared from its normal place. The only thing I was going to ask you, Mr. Patrick Joyce, was does it matter to you whether if you succeed, whether you succeed under the one route or the other? Does it have
no, because
on expenses?
In our submission, once the default judgment is set aside, then I fully admit and accept that we would need to put in an amended defence, and on the setting aside on one or both or either of the grounds, then that would be sufficient.
I suppose it might have a bearing on costs of the application to set aside. If one was mandatory, it's discretionary.
It might, and perhaps we can cross that bridge when we get there. We've both put in cost schedules, and I think therefore are prepared to argue the point. It may be that the court wishes to reserve its judgment and would wish to hear cost submissions in the light of the reserve judgment. So again, I think certainly I'm in the court's hands. I would be surprised if it isn't common ground between myself and the learned friend Miss Hurst, that would be a convenient way of proceeding. Whatever is convenient to the court is probably convenient to us.
No, I'm happy if the Chief Justice is happy that that you proceed to take them in the order you want to take them in. But
please do. Yes, I agree. Let Joyce take the way what he wants, whichever you choose.
Chief Justice, Your Honours, I'm very much obliged. I should formally also introduce counsel. I am Michael Patrick Joyce. I'm appearing for the defendant appellant, Mr. Sethi. My learned friend, Miss Sophia Hurst, appears for the claimant respondent, NS Investments. By way of housekeeping, again, a familiar course by way of introduction, the court should have a complete bundle on case lines, which I think is paginated in various ways. It seems to go from A to ZZ, and also in terms of a running page numbers from 1 to 703. I hope I can provide the court with appropriate page references as we go through. Within the complete bundle, the court should have my skeleton, that is the skeleton argument on behalf of the defendant appellant, dated the 18th of October this year. Excuse me, that is to be found at pages ZZ1 to ZZ15, which in the running sequence of the bundle is pages 11 to 25. My learned friend's skeleton on behalf of the claimant respondent of even date, i.e. the 18th of October 2021, is to be found at pages YY1 to YY17, which is pages 51 to 67 of the running paginated bundle. I hope I'm not going too fast for your honours, because of course this is recorded and page references can be picked up in due course. Both skeletons, as you will have seen, incorporate previous skeletons as appropriate. In particular, my skeleton incorporates the earlier skeleton in support of the successful application for permission to appeal, which was dated 16th or 17th of May 2021. Those were my skeleton submissions. I think I formally put them in on the 16th. They may have been dated the 17th for internal purposes. That skeleton, that earlier skeleton, is to be found in the bundle at section B1 to B22, which is pages 127 to 148 of the bundle.
الاستجابة لدعوة النزول والتظاهر كما شاهدنا قبل قليل أمام مقر.
I'm hearing voices in Arabic. Where is it coming? Okay, it's gone now.
Thank you, Chito. I didn't know whether it was directed at me, so that's why I paused. Yes, I'd given the page references to the skeleton argument, which had been my earlier skeleton argument in support of the application for permission to appeal, which had been incorporated into my more recent skeleton. My learned friend has followed a similar course, and she has incorporated by reference the claimant respondent's response in opposition to the application for permission to appeal, which is to be found at bundle I1 to I13, pages 285 to 297 of the bundle, to which there are exhibits at section Y1 to Y108, which is pages 421 to 528 of the bundle. I can identify the key documents in terms of the orders with reasons, the earlier and original default judgment, and a couple of key documents which the court will doubtless wish a reference to. Would it be convenient for me to continue with my page referencing, because at some stage I'll pause and ask about the court's opportunity for pre-reading, so that I can gauge the speed at which I should take my submissions and hopefully match the speed appropriately to the court's opportunity to pre-read.
Okay, speaking for myself, I've gone through the skeleton submissions as well, the judgment of Justice Ali, and I think I have identified the issues, but I do not know what the other judges, Mr. Justice Glennie and Shamlan, has to say about that.
Well, speaking for myself, I've read as much as the Chief Justice, I think, and I've also delved into the rules quite a bit, and read the authorities referred to. So
yeah, I'm very much obliged, and Justice Shamlan, I anticipate that you probably followed a similar course.
I would say the same, yes. Thank you.
Thank you, Chief Justice, and Your Honours, that's very convenient. Perhaps I can therefore very briefly identify where the relevant orders are to be found and a couple of key documents. The order with reasons against which this appeal is brought, that is the order of the 29th of April 2021, is to be found at bundle E64 to E82, which is bundle pages 216 to 234. The order with reasons giving permission to appeal, dated the 18th of August 2021, is at bundle J1 to J15, the running pages being 298 to 312. The original default judgment of the 1st of September 2020 is at section 01 to 03 in the running order pages 344 to 346 of the bundle. Your Honours will have seen references to something called a reply memo or reply memorandum dated the 9th of August 2020, which we say clearly purports to be a defence. That reply memo is to be found at pages E23 to E25, bundle pages 175 to 177, and the underlying loan agreement, which is relevant to the usurious nature of the interest, is dated the 2nd of July 2020 and is to be found at bundle E4 to E5, which is pages 156 to 157 in the running order. Your Honours, I hope that that is a convenient referencing exercise, and in those circumstances I will turn to my skeleton argument.
Sorry.
Justice.
Yes, I got on my page here E as appellant's chronology.
Oh, yes, that is correct, Your Honour. It does say appellant's chronology, but if you look at the page numbers, it goes page E1 to E82.
Yes.
Now, I know it's always said that lawyers never use one word when 10 will do, but having an 82-page chronology is really pushing at the outer limits of counsel's ingenuity. And indeed, it's only the first pages of bundle E which are the appellant's chronology, and I should have corrected that by way of index. It's the index's mistake. And the bundle E is in fact supporting documentation running from the loan agreement through to the reply.
Yes, I see that. Thank you very much. Thank you.
My apologies for the misreferencing on the index.
The other one, what I was looking for is that what was it? The
reply
defense memorandum.
Yes.
That was what I was trying to hunt for, and I can't find it last night.
Your Honour, it's Chief Justice. It's at page E22 to E25.
Yeah, that's why you say something else and you put something else. That's why I cannot find reply memo sent to IFC. Okay, I got it here. Yes,
I extend my apologies again for the misreference.
I've not read this one yet, I think. Yeah. Yeah, this is what I was looking for last night. I couldn't find. Okay, then. Thank you very much. Yes, please proceed.
Thank you, Your Honour. I'm just making sure that I have that in. Yes, I have that in hard copy form. May I therefore take the court to my skeleton argument, which begins at ZZ1, running page 11 of the bundle, depending on which is more convenient for navigation purposes, or if you have it in hard copy form, then so be it. I have it in front of me in marked up hard copy form.
Okay.
Your Honours, if we are literally on the same page, then I can skip over what is said on page ZZ1 and the first half of ZZ2, because those are simply suggested pre-reading, and I'll begin with the introduction, which establishes what the court already knows, that this document contains the written outline submissions on behalf of my client for the substantive hearing of his appeal against the order which was dated the 29th of April 2021, under which the Court of First Instance refused to set aside the original default judgment entered against my client on the 1st of September 2020. For convenience and to avoid unnecessary duplication and unnecessary fleshing out of what's supposed obviously to be a skeleton argument, we've respectfully incorporated by reference both the, in particular, the skeleton argument dated the 16th of May, which I've referred to, which was the skeleton argument in support of the application for permission to appeal. And also, we have referred quite extensively to the order with reasons granting permission to appeal, because in our submission that will help the court frame the context of the appeal. Then we turn to the circumstances and argument. As I say at paragraph 3, a copy of the default judgment made on the 1st of September is available. I've already provided the page reference. It's provided again here. The default judgment had regard to matters of apparent form rather than substance, and it was largely in standard boilerplate form. So it's there essentially for completeness of the court's cross-referencing. The defendant appellant issued an application notice dated the 21st of September 2020. The reference is again given for the court's convenience. I don't think we need look at that document particularly. That was the application notice to set aside the default judgment. The application was first heard on the 9th of December last year, and as I've already said, by order with reasons made on the 29th of April, the Court of First Instance upheld the default judgment and dismissed my client's application for the judgment to be set aside. And of course, we'll take the court to the CFI order as appropriate. The defendant appellant then issued an appeal notice dated the 18th of May 2021. It was at this point that I became involved in the case, and subsequently those who are currently instructing me also became involved in the case over the summer of this year. But an appeal notice was issued dated the 18th of May 2021, together with skeleton argument, chronology, draft order. But certainly the chronology and the draft order have been overtaken by events, so I'll leave that to one side. There was a further witness statement whereby the application for permission to appeal was made. And of course, going to the second issue, namely the reasonable prospects, the RDC rules require that aspect to be supported by evidence. So the witness statement which is referred to there supports that application, but it's simply making sure that there's full compliance with the requisite rules under RDC Rule 14.2. Then continuing at paragraph 6, as is always the case, an argument in support of an application for permission to appeal also covers matters relevant to the substantive appeal. In particular, we've identified the grounds of appeal which have already been summarised, and we've provided the cross-references to those grounds. The court has indicated that you've had an opportunity to read the skeletons, and by that I assume that that means not only the skeleton of the skeletons of the 18th of October, but also the supporting skeletons. But if there is anything that the court would wish me to take you to in particular, I'm very happy to do so, but I don't wish to weary the court unnecessarily in relation to matters which are, in any event, amply cross-referenced. Now, in paragraph 78 of the skeleton argument in support of the application for permission to appeal, we did say, and I will read this into the record, the court is respectfully invited to grant defendant applicant's application for permission and give all necessary and appropriate directions for the substantive appeal against the order refusing to set aside the default judgment. In particular, the defendant applicant would propose, or the defendant appellant would propose, that the appellant's notice should stand as such in the substantive appeal. The defendant appellant also requests that this skeleton should stand as his skeleton in the substantive appeal in compliance with RDC Part 44.59, and that the reasons set out herein for RDC Part 44.19 being satisfied at the permission stage should also be relied upon in satisfaction of the conditions that must be satisfied for the substantive appeal to be allowed under 44.117 to 44.119. Now, that, of course, relates to issue 2 in relation to good arguable case, reasonable prospects of success, but you can see how I hope all matters have been drawn properly together so that we've complied with all of the requirements of the rules. Picking it up at paragraph 8 of my submissions, really what I've just said, in fulfilment of what was said and has now been read into the record, the contents of that argument, the argument of the 16th of May, is incorporated, or those arguments are incorporated by reference. And then I refer to the claimant's submissions which were in response to our application for permission to appeal. That's a document that I've already indicated is to be found at pages I1 to I13 of the bundle, and which I've termed in the course of my skeleton the CR claimant respondent's response. And I say, despite permission to appeal having been granted, I expected, because of course they were mutual simultaneous exchange of skeletons. So what I had to go on was essentially what the claimant respondent had said in her earlier argument, that dated the 8th of June, and therefore I've looked at that in some detail, and of course that's the document that my learned friend Ms. Hurst has incorporated into her more recent skeleton. So I then look at how that document is comprised, and I hope I do it appropriate justice in the summary. Paragraphs 1 to 12 comprise an introduction and background, which really doesn't, it's very important scene setting. You have that in a number of instances. You have it in my skeleton in the chronology, which has been updated, and matters like that. It doesn't go to the substantive issues. So I have left that on one side. I've also left on one side a slightly tendentious way in which some of those paragraphs are couched, saying that it's convenient to concentrate on the substantive submissions of the claimant respondent.
Yes, please, Mr. Pratt Joyce, you are waiting for your substantive submission.
Good. Well, let me...
I think more than enough. You have covered more than enough. Let's go into what you really want to say.
Fine. Let me skip over paragraph 11 and say that the response to the claimant respondent's substantive submissions, her substantive submissions in the response are essentially paragraphs 20 to 40 of that document. And I have taken that and gone through it in sequence. I will have that open as we go through, but it may be that I can deal with this simply on the basis of what is set out in my skeleton. Paragraph 12 of the skeleton looks at paragraphs 20 to 21, which are the first paragraphs under my learned friend's heading Prospects of the Appeal. They set out the relevant test, referring to Vanin Capital, Swain and Hillman, and DNB Bank and Gulf Ayada. That is common ground in relation to the second limb, the second issue, the good reasonable prospects of success, realistic as opposed to fanciful prospects of success, common ground. Then we say that it's clear that the defendant appellant has satisfied the relevant test, permission to appeal having been granted, and we say that having satisfied that test for permission, then that continues for the purpose of the substantive hearing. As far as ground one, which is the reply memo was a defence, then the court is respectfully invited to begin by rereading paragraph 6.1, 9 first bullet point, 10 to 23, 46 to 51, and 60 to 70 of the defendant appellant's previous argument. Now, if I go back to that, I will just very briefly summarise what is set out there. Paragraph 6.1.
Mr. Patchett, I thought you are going to go on the issue of whether the claim was properly served. I thought that's what you want to go, and then you go on to the other. You're still going on. You're telling us where is what. You know, we'll come to that already. Why don't you go substantially, and tell us why the claim form was not properly served on your client? Go straight there.
Well, Your Honour, that's not a point that I am taking, because the claim form was served. What we say is that a document purporting to be a defence, which is the reply memo of the 9th of August, was served in time.
Okay.
And because it was served in time, that means that there was no entitlement on the claimant respondent's part to enter judgment, and therefore the default judgment should be set aside on that ground.
So the question is also whether that memo amounts to a defence that is required by the RDC.
Whether it complies with the terms of the RDC, because as Your Honour will see, the requirement is that what is served is a document which purports to be a defence. Now, my learned friend has spent quite a lot of time in her skeleton arguments saying it wasn't a defence. It wasn't a defence because it didn't have a statement of truth. It wasn't a defence because it didn't answer paragraph by paragraph, etc. What we say is that is to put the test far too high, because if we had complied with all the points which are now put against us, what would have been filed would not have been a document purporting to be a defence, it would have been a defence. So therefore it would have exceeded the obligation which is imposed on a defendant, which is to file, and we'll come back to filing, to file a document which purports to be a defence.
What rule? Can you refer to the rule again? What rule is it? RDC what?
Yes, it is RDC Part 13, Rule 2, Part 13.2.
Part 13. Part 13.
2.
Part 13.2, did you say?
Yes, Chief Justice.
13.2.
For the purposes of this part, a defence includes any document purporting to be a defence.
Document purporting to be a defence.
Yes.
And your point is a simple one, isn't it? That namely that if given the points made by the other side that it wasn't a statement of truth, and there wasn't set out in the proper way, and so on, all those are irrelevant, because those stop it being a formal defence in proper form. But it still is a document which purports to be a defence because it seeks to answer the claim put against you.
Absolutely.
Is there any more to say than that?
No, if the court is with me on that, that is the short point, and it accurately summarises it.
Even if we're against you, is there any more to say?
I don't think so. We can go to the document, which is at page E23, and look at it, but I'm sure that the court can do that.
Yes, that's what you want to do. I want to go through the document, a memo, and you can explain to us why you say that is a document purporting to be a defense.
Yes, you're right, Chief Justice. I'm very happy to do that.
It's purporting to be a defense.
Yes.
So I have to bear with me a bit. Okay, what page is that again, please?
It is page E23, which is
E23.
page 175 in the running bundle.
E23, find page. Okay, I got it. Yes.
And just to make sure that we are, it should be Y1 in the top right-hand corner. And Your Honour, see that it's reply memo in the case, date 9th of August 2020, subject matter reply memo. In response to what was stated in the claim statement, so referring to the statement of claim, the defendant denies what contained in it altogether. So that is, in our submission, a clear statement that the whole of the claim is denied, and in support of that denial, this document goes on and adding, and it relates to the loan agreement in the first and secondly points on this page. First, the cheque and then details of the cheque are given, was submitted to the claimant as a guarantee under the 5th clause of the loan agreement, which is what the claimant acknowledged in the claim statement, and this cheque for the amount of the loan plus the alleged default interest, which dependent on a standing condition, which is non-payment of the loan amount. So there is an issue, particular issue raised with regard to the cheque, its status, why it was filed, and what its purpose was. Secondly, the defendant paid sums on the loan account and payments transferred to the claimant's account, but they were not calculated by the claimant, and the loan amount was not reduced against the cheque amount in accordance with clause 5 of the agreement. So there is a particular point arising in relation to how the monies which were paid should properly be allocated. Thirdly, the amount of the loan includes usurious interest that violates the laws of the United Arab Emirates and is obscene usury. Now, at first, I had thought that was perhaps itself rather tendentious language until one looks at the interest rate which was being charged. But it goes on that obscene usury is forbidden in Sharia and law and is punishable under Article 409 of the Federal Penal Code, where the claimant acknowledged in its lawsuit that the interest of the loan period is 24%, the default interest is 36%, interest in violation of the legal interest in the UAE, which does not exceed 9%, which, as the court is fully aware, is the interest rate which is specified as the maximum in the DIFC court rules as well. So one has an ability to charge interest, but not of this excessive and extraordinary percentage, namely 24% in the first instance and 36% on default. So that point is clearly made. Then in further defence and indeed counterclaim, because we see that that feeds through to further relief sought on the final page. But looking at Y2, first, the defendant's liability is not...
Before you proceed on, Mr. Paget, after referring to defence includes any document purporting to be a defence, now, where is the word defence that is relevant to that interpretation that you want to rely on? Is it in 13.4 and 13.5?
Well, I'm happy to do. I think there may be two questions implicit in what you've put to me, Chief Justice. If one is looking at this document, where does it say it is a defence? It says it's a defence in terms in the opening lines. In response, so it is responding to the claim statement, the statement or particulars of claim, the defendant denies what is contained in it, i.e. the particulars of claim, altogether. That in our submission is a clear defence, and that is then further particularised. If I can turn to the other aspect.
I'm not referring to that. I'm referring to the rules. When you refer here for the purpose of this part, a defense includes any document purporting to be a defense. So,
yes, well, I think I should take the court perhaps.
Defense, are you referring to, or you mean 13.4, which says a claimant may obtain judgment in default and only if the defendant has not filed an acknowledgement or a defense. In this case, your client has filed any defense. And the 13.5 says judgment in default of defense may be obtained only where an acknowledgement of service has been filed, but a defense has not been filed. Your contention is defense has been filed because the word defense includes the document that your client has filed. Right.
We certainly say it's been filed. It may be convenient just to respond fully to the point you've raised, Chief Justice, with which I agree. And in one sense, I could just say yes, but it may help if I very briefly explain why I say yes in response to what you've said. May I begin by taking the court to RDC Part 13.1? Because this defines what default judgment means. In these rules, default judgment means judgment without trial where a defendant has failed to file an acknowledgement of service or has failed to file a defence.
Okay.
So one starts in my submission with the definition of default judgment in 13.1. One then goes on to 13.2, which must be read together with 13.1. Says, for the purposes of this part, a defence, so this is picking up 13.12. For the purposes of this part, a defence includes any document purporting to be a defence. So one can read the definition of default judgment as meaning judgment without trial where a defendant has failed to file an acknowledgement of service or has failed to file a document purporting to be a defence.
I apologize, Mr. Patrick.
No, it's
I apologize.
No need to apologise at all, Chief Justice. It's very important that we go through these provisions and that the court sees what these provisions say. And first of all, looking at part 13.1, there is the or between 13.1.1 and 13.1.2. And then there is the clarification of what is meant by a defence, first referred to in 13.12, but clarified and amplified by part 13.2.
Yes.
And one then goes on to part 13.4, which is what a claimant must do by way of conditions to be satisfied. The claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not filed an acknowledgement of service or a defence to the claim or any part of the claim, and the relevant time for doing so has expired. So when one looks at this, the full description of a default judgment is a default judgment in default of acknowledgement of service. But the rules expressly provide that that default judgment may only be obtained if either we haven't filed or the defendant hasn't filed an acknowledgement of service, or again the alternative, or a defence which bears the meaning which we've just seen in part 13.2, so a document purporting to be a defence, to the claim or any part of the claim. And the relevant time for doing so has expired. So just to put the chronology, match the chronology to that, the reply memo was dated the 9th of August 2020. The time for service of a defence was the 20th of August 2020 because of the service out of the DIFC jurisdiction, and therefore 45 days being allowed for the service of a defence. And therefore the reply memo purporting to be a defence was filed within time on the 9th of August, when the time for doing so only expired on the 20th of August. So, Your Honour, Chief Justice, no need to apologise at all, because it's very convenient for me to deal with that at the pace that I've just dealt with it, because it's dealt with and set out elsewhere in my submissions, but it's very convenient to deal with it now. And going back to the point made by His Honour Lord Glennie, there is really not a lot more that I can say on this point, because you have rightly seen the way in which that I've put it, and the 14.1 argument looks back at this reply memo. I'm happy to continue to go through the memo.
Yes.
I think I reached Y2.
Yes.
Is it, if I can interrupt for a second, I think in a sense we can all read the memo.
Yeah.
Justice Ali Al-Madani, in giving leave to appeal, in paragraph 26, puts the matter very succinctly, doesn't he?
I think that may be a paragraph that I have taken you to in. But may I just turn that up for present purposes and confirm that
basically what he says is, well, it looks like a defence, it answers the claim, it denies the claim, sets out other matters, all the sort of stuff you'd expect from a defence. And if it looks like a defence, it is it purports to be a defence.
Yes, I have the paragraph. It's J10, page 307.
Yes, that's right. I downloaded it, so I've got it separately.
Yes, and it begins, did the reply memo satisfy this requirement?
Yeah.
And he says that it's at that stage he finds a real prospect of successfully arguing that it did. I think in the course of my submissions I made the point that His Honour, His Excellency Ali Al-Madani was scrupulous to observe the limits of his jurisdiction at the point of an application for permission to appeal, so he wasn't usurping the function of this court, but yes, I have submitted that what he says in paragraph 26 is indeed compelling and leads to an inexorable conclusion.
Yep.
Okay.
So, and I think from what His Honour Lord Glennie was saying, you are happy for me to leave you with the rest of Y1 to 3 to read and consider at the court's leisure, because in my submission we have established, even by looking at the first line and a half, that it purported to be a defence, and then what goes on through to Y3 is really amplification of that. And on Y3 there is relief sought, which is first and originally dismiss the claim of the claimant, so that is again repeating the defence, and secondly what can be spelt out thereafter is a counterclaim, but I don't need to go down the counterclaim route. I simply need to establish that this document purported to be a defence, and for the reasons set out in paragraph 26 of the order with reasons in our submission, that is clearly
In
the
short,
case.
you are saying all the relevant statements that would appear in the defense appears on this memo. That's what you're saying, isn't it? Everything one would say in a defense, maybe drafted legally by a lawyer, but substantially will be the same.
Yes, I don't want to bind myself to saying that we'll only rely on what's set out there, because what's set out there in my submission does need to be clarified. And in the course of that exercise, putting something more clearly, there may be 2 or more roads that lead to Rome. So I don't want to be bound by the 4 corners of what's set out there. But yes, it is a document which purports to be a defence. I acknowledge and have always acknowledged that it will need to be redrafted in a form which is more usual and convenient for the DIFC courts. And we will do that. We will amend as appropriate.
Can you help me with the meaning of purport? What does purports mean?
Well, purport is, my learned friend suggests, professes, something which indicates that it is of the nature of a defence. It is clearly something less than a formal defence, for the reasons that I've already referred to. If we had done everything absolutely punctiliously correctly, what it would have been a defence, not a document purporting to be a defence. So a document purporting to be a defence is plainly something less than a formal defence. So therefore, in our submission, one should not take formal points, one should look at the substance. And it only needs to be a defence as to part of the claim. That again is clearly derived from part 13.4. And we say that it clearly fulfills the necessary requirements.
Okay. Yes. I'm clear. Thank you.
Thank you, Your Honour. Thank you, Chief Justice. So let me have a look and see how quickly I can pass on. If I go back to paragraph 13, I've set out a rather extensive recitation of paragraphs in the earlier argument, which I think I probably covered in answer and response to the court's questions. And we say at paragraph 14 that the claimant respondent, certainly in the document of the 8th of June, doesn't really engage with the point that the reply memo purported to be a defence. And we say there's no substantive answer to that point. And indeed, paragraph 27 of that response, the claimant respondent simply leaves it aside. And then paragraph 16, and this really comes to another point which, Chief Justice, you raised in the course of argument. In shifting, the claimant respondent takes at what we say is a manifestly bad point when it contends that the reply memo was not filed, underlined, within the relevant time or at all. That's paragraph 27 of the claimant's response, with the underlining being in the original. And we say the underlining is presumably intended to focus attention on the word filed. Contention being that sending the document to the court and receipt by the court of the document does not amount to filing. Well, not only do we say that is plainly wrong, we make that argument good at paragraphs 39 to 51 of our skeleton argument. If I may take the court very quickly to that, which begins halfway down page ZZ11, page 21 of the bundle. And here we think that the starting point, or submit that the starting point, is part 2 of the rules of the DIFC courts. Part 2.5 provides as follows. We've set it out extensively, so no need to divert from this document for present purposes. Part 2.5 provides that unless the context otherwise requires, the words and expressions set out in the schedule to this rule shall have the respective meanings assigned to each of them for all purposes in connection with these rules. So there in part 2.5 you have express incorporation of the schedule, and at paragraph 41 of my submissions we go to the relevant definitions in the schedule. The schedule to part 2 provides the following relevant definitions. E-filing, the electronic filing facility available on the DIFC court's website used for the electronic submission of documents to the registry. Filing in relation to a document means delivering it by post or otherwise to the registry. Exactly the same definition as in the CPR. Continuing, we've already looked for different purposes at Rule 13.4, but that provides the claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not filed an acknowledgement of service or a defence to the claim or any part of the claim, and the relevant time has expired. So here one's focusing on what Rule 13.4 says about filing, and it expressly refers to filing, not e-filing, and there is a difference between the two, obviously, but that is a difference which follows through from the definitions. Paragraph 43, I think it's probably fairly obvious the way in which my submissions are going. It's noted that RDC Part 13.4 refers expressly to filed, not e-filed. The context does not otherwise require, so looking back at the introductory words to Part 2.5. Thus, RDC 13.4 is satisfied when the document is delivered by post or otherwise to the registry, definition of filed in or filing in the schedule. That plainly occurred on the 9th of August, i.e. well before the 20th of August, and therefore before the relevant date for so doing had expired. Part 13.4 precludes, by reason of the use of the word only, precludes a default judgment being entered in the present circumstances. Quite simply, had e-filing been a requirement, then Part 13.4 would have said so. It doesn't say so, and therefore e-filing isn't a requirement under that part. And it's submitted that the above analysis must be correct and provides a clear answer to what was the third question of 3 posed by His Excellency Judge Ali Al-Madani in the course of granting permission to appeal, namely, was the reply memo filed for the purpose of RDC Rule 13.4? And then, of course, we go on to support that clear, concise conclusion by reference to other parts, which again picks up reasoning set out elaborately and correctly by His Honour Judge Ali Al-Madani. We say we don't need to go there, but if we do go there, we come to the same answer. So again, more than one route to Rome. And I'm happy to read into the record extensively what we say in paragraphs 46 through to 51. But perhaps I need only take the court to paragraph 50, where we set out again extensively.
Hang on, before you proceed, Mr. President. Are you saying that by virtue of 13.4, you cannot file an acknowledgement of service by e-filing? Or
No. No, I'm not saying that.
Because it says here in your bracket there, e-filing, the electronic filing facility available on the DIFC court website, used for electronic submission of documents to the registry. filing in relation to a document means delivering it by post or otherwise to the registry.
Yes.
But everything in this document doesn't speak of e-filing. It speaks of filing.
Correct. And that is the point, Chief Justice. That is the point, and it may be convenient to answer the point you've just raised if I do take it a little bit more slowly and take you to the paragraphs I was going to skip over. The point is this. The reply memo of the 9th of August was submitted and received by the court by email as an email attachment. So it was an electronic document. It wasn't an electronic document which was e-filed through the portal. So you can have a paper document, you can have an electronic document which is submitted not through the e-portal, and you can have an electronic document submitted through the e-portal. Now, the court would like people to submit electronic documents through the e-portal, but that is e-filing. When one looks at Rule 13.4, that talks about filing. So that would encompass a paper document being delivered by post or otherwise to the registry, or an electronic document similarly being delivered otherwise to the registry. And we know that this document was received. So what I've sought to do in paragraph 46 is to look at other rules of the DIFC courts and explain that. I've now had an opportunity to explain it orally in response to your question, Chief Justice. But going back to paragraph 46, we say the answer, which we've provided at paragraph 45, which is where I paused, the answer is, of course, also supported by the reasoning of the learned judge at paragraphs 27 to 33 of his reasons for granting permission to appeal. The learned judge referred to part 16.5, which says a party may, permissive, may file a defence by submitting it electronically using the court's e-filing system, emphasising the word may. This is plainly, we say, permissive, not mandatory. The e-filing system may be used, and indeed the courts may encourage its use, but it is not required. Part 6.20 of the rules provides that all documents to be filed in the DIFC courts should be submitted to the courts in electronic form only. That's what we did. It was an attachment to an email, preferably through the e-filing facility available on the DIFC court website, subject to an exception which isn't presently relevant. So that's why I drew a distinction between the three types of document: hard copy, electronic but not filed through the e-portal, and electronic filed through the e-portal. And as between a document in electronic form, we should submit those documents in electronic form only. We did, preferably through the e-portal. We didn't do that, so we did not follow the preferred course, but we clearly followed a course which was expressly contemplated by the rules. And that's made good at 48. Part 6.21 provides that electronic documents may be filed with the courts by 1, the e-filing facility. This should be used unless it's impossible in the circumstances, or emailing the documents to the registry. And we emailed the documents to the registry. So paragraph 49, we followed one of the courses clearly set out in the RDC for filing documents, just not the preferable course. And the concluding point is as follows: if a party follows a course provided in the rules, it cannot be said that it has not thereby properly filed the document. And that's really, in our submission, all that needs to be said. But we can take it back to what His Excellency Judge Ali Al-Madani said, paragraph 33 of his order with reasons. He said, "For my part, I think the word preferably in RDC Rule 6.20 is inconsistent with a mandatory obligation, where possible in the circumstances, for electronic documents to be filed using the e-filing facility. And to the extent that there is ambiguity as to the proper construction of Rule 6.211, in my judgment, this ambiguity should be resolved in favour of the party seeking to defend a claim against him in the usual way, rather than a party seeking judgment without trial by an administrative act of the court. Now, in response to that, to complete this point, paragraph 51, save only that we would respectfully submit that there is, in fact, on analysis, no ambiguity for the reasons that I've just taken the court through orally. We say that the analysis of the learned judge is again compelling. The reasoning of the learned judge is it's submitted correct. The conclusion is categoric. And one ends up with this position: the reply memo, a document purporting to be a defence, was filed on the 9th of August 2020. It was in time, and that being so, default judgment cannot be entered. So you've taken me to a very important element, which is whether this document was filed. It plainly was filed. So if I can just regroup in relation to the points in the skeleton argument, I think I have covered ground one, which is that the reply memo was a document purporting to be a defence. Perhaps I can very briefly take the court back to paragraphs 21 and following, which deals with ground 2. This is ZZ7, page 17 of the bundle and following.
Just before you do that, ground 2, if you're going on to ground 2, just on ground 1, isn't there one further point that needs to be at least mentioned? And that is the default judgment was applied for on the basis not only of absence of a defence, but absence of acknowledgement of service. And one point I thought you were going to deal with was, I thought you were going to be submitting that no acknowledgement of service was required in a case such as this.
Absolutely.
And you haven't
did you? I apologise if I haven't dealt with that. It's a case of over-familiarity, meaning that one misses a step in the argument. But I need in that regard...
Seems to me fairly plain from reading Rule 13.5. Sorry, reading 11.21. That acknowledgement of service doesn't have to be filed in all circumstances, and you fall within both 1 and 2.
Yes.
Sub rules 1 and 2 of that.
Yes.
Until such time as the defence was due but not served within the right time, then there was no even prima facie requirement to serve an acknowledgement of service.
Yes, I would respectfully adopt what's said in Part 11 in parallel with what's said in Part 13.4. And it was 13.4, and it was in the course of reading 13.4 that I stressed the word or, and of course that picks up what Your Honour has just taken me to in relation to Part 11 too. The claimant may obtain. The claimant may obtain judgment. Yes, the claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not, and then there are alternatives, has not filed either an acknowledgement of service or, that's the importance of the word or, a defence to the claim or part of the claim. Yeah. And the relevant time for doing so has expired. So I can get there on the four corners of Rule 13.4 because of the clear word or. That's supplemented.
Because there was no time for acknowledgement of service, so therefore that time can't have expired. and the next stage was a defence, and you had served one, you say, within time. But
Exactly.
the other point to note is, and this seems to be overlooked in the application for default judgment, is the 13.5, because the default judgment was applied for in default of defence as well.
Sorry, yes, I
And
should, yeah.
13.5 says you can't get a default judgment in default of defence unless an acknowledgement of service has been filed. Because where you haven't filed acknowledgement of service, you can't get judgment in default of defence. But you then go back to 13.4, and it falls within that rule rather
Absolutely.
than 13.5.
Yes, but,
And
yeah.
you've explained why they can't get it under 13.4.
Yes. And then one brings in the further point in relation to Part 11.2.
Yes. Yes. Thank you.
Yes. I'm sorry, my lord, if Your Honour, if I didn't fully deal with that point. I had thought but yeah. I hope we're there now. Yeah. Have I appropriately now responded to the point that Your Honour?
Yes, thank you.
I'm very much obliged, and I'm very grateful to the court for seeking clarification on that point. So again, let me pause because I am moving to ground two. Does the court have anything else that it would wish to ask of me at this stage?
The only question I had is that the submissions you make necessarily involve the proposition that you can serve a defence even though you haven't served an acknowledgement of service. And that's what I've just been looking at with you within the rules. That seems to fall counter to the obiter remarks of Justice Sir Jeremy Cook.
Yes.
In the
Bankmed case.
Bankmed case.
I don't know whether you want to say anything about that or whether you propose...
Well, I have briefly dealt with that at the end of my submissions. I'm happy to deal with it now. In the course of preparation, yes, we looked at that judgment in some detail, and I think it's paragraph 27, which contains the flaw, and having done so, we respectfully agree with the point raised by His Excellency Judge Ali Al-Madani. One must give the rules their ordinary meaning, and the rules must have their ordinary effect. And doing so, in our submission, the obiter dictum of His Excellency Sir Jeremy Cook should not stand. It does not withstand the more detailed scrutiny which we've had an opportunity to devote to the rules and this particular point, than I think was probably the case in the Al-Baghuti case, where he made the obiter remarks that we've just been discussing.
Yes, thank you.
Yes, the Abu Adas and Al-Baghuti. And I'm happy to take the court specifically to the provision, but we, as I say, we subjected it to some analysis, and you'll recall that at the end of this passage in the order with reasons in August, His Excellency Judge Ali Al-Madani carried out an exercise which essentially was a reductio ad absurdum, and said it would be startling if this were the case. And again, we worked through that, and we can find no flaw in the reasoning of His Excellency Ali Al-Madani, and when one does get to a reductio ad absurdum, one really reaches the conclusion in my submission that the obiter cannot stand.
Yes, thank you.
Turning to ground 2, again, I've really covered this. The usurious nature of the loan agreement. We've looked at the percentages. You've seen the loan agreement. You have the references to the page numbers, and you have references to the earlier argument in paragraph 21 of my most recent submissions. In paragraph 34 of the response, the claimant says, well, it contends that the arguments over the usurious nature were raised before the court of first instance, and then asserts that, quotes, notwithstanding the flawed and misunderstood allegations of usury, well, just pausing there, there's no elaboration by my learned friend as to why allegations of usury are flawed or misunderstood in this context. But she goes on, the penal code is a criminal statute. It's not open to the defendant appellant to rely on the crime of usury as a defence in civil proceedings. Well, with respect, we simply don't understand this. We go back to our argument in May. We posed the question, was the transaction usurious? And we then deal with the penal code being a criminal statute point expressly in paragraph 23. We say, yes, it is, and that is exactly the point, because what is excluded in the DIFC jurisdiction are the civil and commercial laws of onshore Dubai and the Federation of the UAE. The UAE criminal law does apply in the DIFC, and for it to be suggested that that is not relevant, we simply don't understand. And then for it to be suggested that it's not open to the defendant appellant to rely on a crime of usury as a defence in civil proceedings, again, with respect, we don't understand that, because illegality is, we submit, a plain defence. Equally, a party cannot benefit from its own wrong is well established, the Al Hussein and Eton College line of authority. But we don't stop there, because we put it in the wider context as well of UAE public policy. There is one unitary UAE public policy. If you have a contract which plainly has usurious rates of interest, that is something which we say should and is quite appropriate for it to be argued. We then continue by saying that the claimant's response is quite inadequate. The exact consequences of the loan agreement being usurious need in our submission to be properly considered. And we say at the very least that provides a defence to the substantial part of the claim relating to interest. But we contend that it goes further, because of illegality and or by reasons of public policy, which we characterise as a quite flagrant infringement, that needs to be investigated by the court in a full hearing. We then turn to other matters which are raised by the claimant, which is where references are made to our alleged conduct and other debts. We say that the characterization of our conduct is wrong, and both in relation to conduct and debts, reliance thereon is irrelevant. We set out the reasons why in paragraphs 26 and 27. Paragraph 28 is putting matters in context, and then paragraph 29 picks up a particular point about whether evidence had or had not been admitted by the court, and which I have dealt with towards the end of these submissions. We then look at the order with reasons granting permission, and say at paragraph 31 that whilst this court is obviously not bound by what His Honour Judge Ali Al-Madani said, the court may derive assistance from it. And then we go through. Paragraph 32 relates to Bank Med, and also a point raised about lack of clarity in the rules. I'll come back to those points very briefly. I think I probably dealt with the Bank Med case already in submissions. Then we set out at paragraph 33 the 3 steps that His Excellency Judge Ali Al-Madani took in reaching his decision that permission should be granted. When was the earliest that the conditions in Rule 13.4 could be satisfied? Was reply memo a defence for the purposes of Rule 13.4, and was it filed? If we look at paragraph 36, picking up the point that His Excellency Judge Lord Glennie raised earlier, I've set out extensively what was said by His Excellency Judge Ali Al-Madani in paragraph 26. Then going over the page, we come through to the logical conclusion of that reasoning, which again I've dealt with, paragraphs 37 and 38. Paragraphs 40 to 51, again, I've dealt with. Then at paragraph 52, I come back to ancillary points, or further points, they're not ancillary. The Bank Med case, I looked at that and submit that it should be revisited, paragraphs 52 to 54. Insofar as there are any infelicities about rule numbering and matters like that, our submission is that that should be referred to the Rules Committee or the Court Users Committee. It's probably convenient for those matters to be picked up and ironed out there. The unresolved matter is whether evidence was or was not admitted in December, but we say at paragraph 58 that it's submitted that it's not necessary to resolve that question for the defendant appellant to succeed in this appeal, and on that basis we don't detain the court further, but we reserve our rights. And then one comes to the concluding paragraph, which really adds nothing to the submissions that I have made. Your Honours, I hope that is a convenient way of dealing with the submissions to be made on this appeal. If there are any points arising, I'm very happy to deal with them now.
Judges, any questions for Mr. Joyce?
No.
Okay, can we take a short break, say about 20 minutes or half an hour with Judge Shamlan and Angus? Can we do that?
Yes,
Sure.
Miss Hurst, how long do you expect to take?
My lord, conscious of the time, I can probably.
No, I'm not rushing. No, I'm not rushing you. Take your time. I just need half an hour break or 20 minutes or half an hour break, and then but I just want to know roughly how. I'm not rushing you. Don't worry about it. Okay.
I anticipate I will take a good hour, but no more than that. So a short break is certainly convenient for the purposes of my submissions.
Yes. So you don't mind? Take a shot. What's the time now in Dubai, Shamlan?
Almost 1:30.
Oh, you have done your prayers?
No, not yet. I have to go now.
I'm breaking for my evening Asar prayers. That's why, because otherwise sunset is coming very soon. So otherwise I'll do some prayers. So thank you very much. We'll come back in half an hour.
Half an hour. Yeah.
Half an hour.
In half an hour.
Thank you very much.
I'm obliged.
Perfect. So should the court resume at 2 p.m. Dubai time?
Thank you.
Perfect. Thank you.
Yes, Miss Hurst, we are ready.
Thank you, Your Honours. I'm grateful to my learned friend for taking the background in in quite some detail, as that will allow me to be somewhat briefer in my submissions. My only point of housekeeping is to sort of point out again, my learned friend referred to the skeleton argument submitted on behalf of the respondent in response to the application for permission to appeal. My updated skeleton argument is at tab YY, and I will be focusing my submissions based on the arguments set out in there. So it's probably useful to have that to hand. I'm working off the electronic bundle, so I'm afraid going to be using letters and internal pagination rather than the overall pagination for the bundle, and I hope that's convenient. Based on my learned friend's submissions, what I propose to do in terms of the running order, if it's convenient to your honours, is that in my submission there are two overarching points of what I would call scope of this appeal, one of which I intend to deal with up front, and the other I intend to park, if I may, and come back to it. Those points are the following. We say, firstly, that the ground one of the appeal, that the default judgment must be set aside because it was not served in time, that is a new argument that was not raised in the court below, was not, and some aspects of which were not even raised by the appellant, but were raised by the judge of his own motion in granting permission to appeal. For the reasons that I will elaborate on, we say that it is not open to the appellant to argue that point, and that the appeal should be dismissed on that ground alone. I'll come on to that as my first point. The second point of what I would call scope relates to ground two, but I propose to deal with it at the end, if I may, subject to your honours, of course. That point is that we say that permission to appeal was not granted in relation to ground two, that in giving his reasons for permission to appeal, the learned judge did not find that there was any real prospects of success of an appeal on the basis of RDC 14.2, i.e. real prospects of success on the merits. And we say, again, for that reason, there is no appeal, that permission has not been granted in relation to ground two. And so that is not a matter that is properly before your honours. I intend to deal with that at the end, if I may, because in my submission, you can take ground two very briefly indeed. We say whether or not it's in front of your lordships, it has no merit whatsoever. But again, it is our primary submission that is not a matter that is before this court. If one looks at the order with reasons of the learned judge, granting permission to appeal, that's tab J, and at page J3, His Excellency Justice, paragraph 3, my lord. His conclusion is that having considered the permission application, I'm less certain that the conditions stipulated in RDC 13.4 for entering judgment in default of acknowledgement of service were satisfied. I think the defendant has a real prospect of demonstrating that the set-aside application should have been granted. Pursuant to RDC 14.1, permission to appeal is accordingly granted pursuant to RDC 14. So that's the ground on which the learned judge found that there was a real prospect of success. And then in paragraph 4, the learned judge goes on to say that he has highlighted this point arising from the BankMed decision that he considers ought to be re-looked at. And one sees at the bottom of that page, J3, the final sentence of paragraph 4. In my judgment, this constitutes another compelling reason why the appeal should be heard, and permission is granted for this reason also, pursuant to RDC 44.19.2, and that, as your honours know, is the provision saying there is some other reason why the appeal should be heard. So in my submission, that's the totality of the appeal. The learned judge found that there was real prospects of success on arguing the, if I may call it shortly, the filing point, and that there was a discrete point arising out of BankMed which constituted some other reason why the appeal should be heard. But he did not, in the course of the remainder of this order with reasons, at any point address the argument that has been advanced by my learned friend in relation to usurious interest. I accept he did not explicitly say in terms that permission to appeal was not granted on that ground, but at no point in this order did he find that that ground of appeal had any reasonable prospects of success. Now, if your lordships nevertheless want me to address you on that, I will do so at the end, and I will say that that was quite right in his conclusion. But we do say that it's not a matter that is before the court at all. And so there is a difference between my learned friend and I, which perhaps I will come on to, about what the point of the appeal is, or what happens if my learned friend does succeed on the appeal on ground 1, because we say ground 2 is not open to him, and that therefore there is a real issue as to what then happens in this case. But perhaps I will address that in due course, if I may.
Sorry, Ms. Hurst. Once permission to appeal has been given, doesn't it open to the appellant to take up any grounds at all, or it's just limited to that grounds?
In my submission, not, Chief Justice. That RDC Part 44 clearly envisages that the parties must lay out the grounds on which permission to appeal is sought, and that the learned judge, in assessing whether to grant permission, can, and it is open to him to do so, grant permission on discrete points only. And we say that's what's happened in this case. So we say that there is no live appeal in relation to the usurious interest. But in any event, and I will address your lordships on that in any event, in case you're not with me on that point, we say that it would have no prospects of success whatsoever. So that's ground 2, but if I may, subject to your honours, I propose to park ground 2.
Ms. Hurst, just before you leave that, I don't want to take you out of order, but doesn't one have to look at the actual determinative part of the order, which is in the first 2 pages of the order giving leave to appeal? It doesn't, as judges can do, it doesn't restrict the grounds of appeal to any particular aspect.
My lord, I accept that the order does not say so on its face, but I say it is clear from the reasons that Justice Ali Al-Madani did not intend to and did not give permission to appeal on the ground relating to usury. Perhaps I can come back to why when I deal with it nevertheless on the merits in my alternative submission, if that would be convenient. So if I may leave ground 2 for now, and coming back to ground 1, again, as I say, we say there's a sort of preliminary point about scope of the appeal and whether it's open to Mr. Sethi to make this argument. Now, my learned friend didn't outline in his opening submissions the underlying dispute, as it were. And that's in some senses fair enough, as he's only been instructed in relation to the appeal. But I think it's useful as background for me to briefly take your lordships through the shape of the dispute and what happened below, as that will orient my submissions. I should make clear, for the avoidance of doubt, that I have been counsel for Earnest Investments throughout this case, and so I did appear in front of the learned judge at first instance. But by way of background, and it's set out in detail in the earlier skeleton argument behind tab I, if your honours wish to refer to it later. This is on its face a very simple claim relating to a loan that was granted in July 2019. Repayment was to be by September 2019, and no payment has ever been made. Your honours will have seen the relevant dates from the order with reasons of the learned judge below at tab W. And I would encourage your lordships to read the full background to the case in that section. It's set out from paragraph 2 onwards at page W3. W3, Chief Justice. There one can find the background facts to the dispute, but by way of very brief summary, and I apologise for the the briefness of it, but this was a brief loan in the amount of around 1.2 million US dollars, granted in July 2019. It was a 60-day loan to be repaid by the 3rd of September, so what one might call a fairly short-term bridging loan. And interest was, as set out in paragraph 4, to be charged at a rate of 24% per annum. What then happened was that a cheque was issued but not honoured, and that cheque bounced, and there were separate proceedings in the onshore courts relating to that. But in essence, since September 2019, no part of the capital of the loan has been paid. Some payments were made by Mr. Sethi in relation to interest, and they were accounted for in the particulars of claim and given as credit on the sum that was claimed. That's all recorded in His Honour's reasons. In terms of the procedural history, the relevant dates are at paragraph 13 onwards at page W4. And this is, I understand, all accepted and uncontroversial. But just for your Lordship's note, if you want to look back at the relevant dates, the claim form was served on the 6th of July. It's common ground between the parties that the period for an acknowledgement of service, I should say common ground with the caveat of my learned friend's submission that no acknowledgement of service was necessary. But it was, if I can put it neutrally, if an acknowledgement of service was necessary, the date for that would have been the 3rd of August 2020, and therefore the deadline for filing a defence was the 20th of August 2020. And you will have seen that the focus of the appeal now is on this document filed on the 9th of August, the reply memo. However, it's worth noting, and I'll come on to this in more detail, that that was not the focus of the hearing before His Excellency Justice Al-Madani, and in fact that application proceeded in relation to a quite different document entitled defence statement, I beg Your Honour's pardon, and that's the document that can be found behind tab Q. That was filed with the application to set aside on the 20th of September 2020. So we say for, and I'll come on to the detail, but I think it's useful to have paragraph 12 onwards of my skeleton argument to hand. We say that this is the point that is now taken, that the reply memo constituted a defence and that it was filed in time, is a point that featured absolutely nowhere in the evidence, argument, submissions and judgment below, and that on established authority it is therefore not open to Mr. Sethi now to argue that point on appeal. As set out in paragraph 13 of my skeleton, the application on its face purported to be filed under both of 14.1 and 14.2. But as the learned judge observed in giving his reasons for permission to appeal, very little was actually said about 14.1, which was implicitly relied on. The entire focus of the application, I think it's fair to say, was on arguments under 14.2. And at the hearing of the application, Mr. Sethi's then counsel, Ms. Tung, relied almost entirely on arguments under RDC 14.2 on the merits. Pausing there as to the merits, I should just say for completeness that the range of defences that were advanced at first instance were extensive and encompassed points not just on usurious interest, which is now taken, but also points about the bounced cheque, about whether payments had been properly accounted for, and a whole range of allegations which were said to constitute set-off. And that was the focus of the hearing, and one sees from paragraph 30 onwards of the judge's reasons, the judge grappling with those issues. But as far as 14.1 was concerned, the only argument that was briefly advanced in relation to the reply memo at all was that it should in fact be deemed an attempt to acknowledge service, albeit one made out of time. Your Honours will recall that date for acknowledging service was the 3rd of August, and the reply memo was the 9th of August. At no point was it argued by Mr. Sethi's counsel that the reply memo was a document purporting to be a defence, as is now said, and served in time. And we say that that is in fact entirely inconsistent with the argument made, albeit briefly, that the reply memo should be treated as a late acknowledgement of service. And that's clear on its face from the order that was made below at page W6, that no submissions have been made by Mr. Sethi that support the application insofar as it is made under REC 14.1. Now, of course, as your honours have heard, my lord, yes.
Can you help me? Sorry to interrupt. I hear what you say about what reliance was placed upon the memo, the reply memo, as an attempt to acknowledge service. But that was in support of the case that the application should be set aside without any discretion under 14. Is that right?
Yes, my lord, yes. It was in response to a brief question as to whether the applicant was relying on 14.1 at all.
Yeah, so there was reliance on 14.1, albeit under this slightly different way of arguing the case.
To that brief extent, my lord, yes. And so to that extent, what's said at page W6 in relation to 14.1 is perhaps not fully fleshed out, although certainly the substance of it was that no real argument was made under 14.1.
But if reliance was placed on the reply memo in the context of a challenge under 14.1, then all we're really concerned with here is a different way of relying on that document in support of that challenge, aren't we?
My lord, I wouldn't characterise it precisely that way for this reason, in that the only point at which it was raised was not by way of submissions, but in response to a question to the effect of, are you relying on 14.1 at all? And it was a very brief answer in relation to this possible point about an acknowledgement of service. It didn't feature in the skeleton argument, so far as I can recall. And in the context of an over 2-hour hearing, it was a matter of about less than 5 minutes. Just to put that point in context. But in our submission, the circumstances in which a new point can be raised were dealt with in the case cited at paragraph 16 of my skeleton argument, the Damek Park Towers Company Limited and Yusuf Issa Ward. It's behind tab YY, the sub-document 2, it's called, which is entitled Exhibit to Respondent Skeleton Argument. These are the authorities relied on. If one goes to page YY35, apologies, I'm just scrolling down to get there myself. This is where the court can find guidance as to when a new point can be raised for the first time on appeal. So if one goes, the point is dealt with beginning at paragraph 65, which is page YY55. Apologise, this page on my screen is rather slow to load. And here, in the Damek case, as here, 2 new points were raised for the first time on appeal. They're set out at paragraph 64. In paragraph 65 onwards, the Court of Appeal sets out the relevant tests. Paragraph 65 there, the court recognises the importance of the long-standing principle that an appellant should not have free rein to introduce points on appeal that were not advanced at trial, quoting a judgment of the Tasmania Lord Herschel, who says that a point not taken at trial, presented for the first time in the Court of Appeal, ought to be most jealously scrutinised. At paragraph 66, the Court of Appeal says that where the question raises one of pure law, which involves no further factual investigation, then a court has no reason to preclude admission of the new point. The interests of justice require the point to be considered. Then, scrolling down to paragraph 68, the position is more restrictive where the new point raises raised presents factual questions which might affect the evidence or the conduct of the trial if the new point was raised then. And then in the words of Lord Justice Ricks in the Lowen Mashal joinery case, and the words that one sees there in bold type, it has generally resisted doing so where a new issue of law is raised in this court, which, if it had been raised below, might have affected the evidence or the conduct of the trial. And so the thrust of the guidance that we get from the Damak case is that it's only appropriate to allow a point to be taken on appeal that was not taken at first instance if the point is one of pure law which involves no further factual investigation, i.e. if the new point had been taken below, it would not have infected the evidence or the conduct of the trial. My lord, I apologise, I didn't see you had raised your hand.
Who?
Is that not a hanging hand, or does my lord have a question?
I don't. Well, since you've stopped it, I do have a question, but I hadn't raised my hand. Isn't this the case where it's a point of law or construction and doesn't involve any evidence?
My lord, in my submission, not. For this reason, Mr. Sethi's evidence filed in support of his application, that was filed on the 20th of September 2020, that did not allege that the reply memo constituted his defence. In that application, he relied on the entirely separate defence statement, which was also filed together with that application, although not filed as a defence as such. That's the document at tab Q, headed defence statement. And it's not an exaggeration to say that the entire premise of Mr. Sethi's application at first instance was that the defence statement was his defence, and that the points made there had a real prospect of success. That was his evidence. Now, of course, my client then responded to that evidence. It was the points raised in the defence statement which were responded to in the first witness statement of Mr. Vinay Sarana, which was submitted on behalf of my client. That's the witness statement at tab R. And then Mr. Sarana makes clear in that witness statement. Of course,
if I can for a second, I appreciate that it may go to what is in the document may go to the merits of the dispute and may be relevant to evidence given on the merits, but in terms of compliance with the rules or otherwise, the argument is simply about whether a document purports to be a defence and whether it was filed and what time it was filed and so on, and that's all a matter of construction, isn't it?
Well, my lord, we say not. We say it's more fundamental than that, because the application was based on whether the document that was filed as a defence had real prospects of success. Now, it's quite a different thing for my clients to meet the document that is now raised as the defence, as to meet the defences articulated in the defence statement and the way in which they are articulated. And so the entirety of my client's evidence was geared towards responding to the document that at the time was said to constitute the defence. Further, of course, in the hearing itself, that's what argument concentrated on. The defence statement was scrutinised by counsel and the judge. And of course, in the order with reasons, which is set out from paragraph 30 onwards, the document behind tab W, the learned judge considered that the defence is set out in the document entitled Statement of Defence and analysed the defences that were contained in that. If it had been said that was not the defence at all, but that the defence was contained in a separate document, then the evidence would have been different. And in the words of Lord Justice Ricks, the conduct of the trial would have been different. The conduct of the hearing would have been different. Moreover, and for reasons that I'll come on to, if what was being said by Mr. Sethi had been, I filed a document on the 9th of August and that was my defence, then one would have expected his evidence to say so, and argument and evidence would have focused on that point. But actually at the time, Mr. Sethi's evidence was that he had been ill during that period and that he had struggled giving instructions to his lawyers. But there was no suggestion that what he had done was actually comply with the rule. And those submissions were obviously rejected by the learned judge at first instance, but through the entire application, the documents that were filed from the 20th of September, the evidence filed in support, another round of evidence that was belatedly filed on the 6th of December, his counsel submissions at the hearing, responsive evidence and responsive submissions, and then the judgment all proceeded on the basis that the defence statement was what was being claimed to be the defence, and that was what was to be scrutinised for the purposes of Rule 14.2. And so we say that this is a case where the new issue of law that has now been raised for the first time would have affected the evidence, and it would have affected the conduct of the hearing. The argument before Mr. Justice Al-Madani would have been completely different. We say the respondent would suffer prejudice if Mr. Sethi is now permitted to have it both ways and chop and change between which document is said to be his defence, depending on which legal argument he's advancing. So we say that this is a case that falls within the wrong side of the line, if I can put it that way, of the distinction that's drawn in the Damak case. And so we say he shouldn't be allowed to advance it now. Now, of course, that's my primary submission, but without prejudice to that, I will address the points that are said that are advanced in relation to the argument under 14.1. My Lord, does my Lord have a question?
Yeah.
So if I might take the submissions in this order, there are, it seems to me, three key areas of contention between my learned friend and I. The first is whether the reply memo purported to be a defence. The second is whether it was filed. And the third is whether it being common ground that no acknowledgement of service was filed, whether that is itself fatal to the application. And so I will deal with them in that order, unless Your Honours have a different view. So my learned friend addressed you on this and said that, in essence, whatever, whether or not this was a compliant defence, this was at least a document purporting to be a defence within the meaning of RDC 13.2. Now, it seems that between my learned friend and I, we don't think that this provision has been the subject of any judicial consideration. I certainly wasn't able to find any authority on what purports to be means. And so in my skeleton argument at paragraph 23, I've set out that one therefore must take a common sense approach, a sort of dictionary definition approach, if one will, and give the words purports to be its common sense English language meaning, which I say is something which professes, pretends to, or appears on its face to be a defence. And we say that that's not complied with in this case. Now, I accept, of course, that the rule allows for some flexibility in that a document may not be fully compliant in all respects. That's clearly the purpose of this proviso of purporting to be a defence. As my learned friend says, a perfect defence is not what's called for, because that would be a defence. I accept that. However, in my submission, if there is a spectrum between a perfect, compliant in all respects defence and a document which does not even purport to be a defence, we say this is the wrong side of the line. And in particular, we say that one should not have to qualitatively assess a document and go through line by line to work out if it is or is not purporting to be a defence. If something purports to be something, it has to do that on its face. It has to give the appearance of being that on its face. It has to be recognisable as such, if I can put it that way. And here we say that the reply memo was not recognisable as trying to be a defence, or it did not appear to be a defence, or profess to be a defence, whichever of those formulations Your Honours prefer. And I've set out the reasons why at paragraph 24 of my skeleton argument, but we say this is not a document where it looked like a defence, albeit with some technical glitches, which is what is advanced in Mr. Sethi's skeleton argument. We say it didn't give the appearance of being a defence at all, because it wasn't a case where it didn't comply with some of the requirements, but it didn't comply with any of them. So firstly,
what are the requirements that he has not complied with?
Well, firstly, Chief Justice, and most obviously, we say that the document is not entitled defence or anything similar. The title of this document is reply memo. We say that on that basis alone, it does not profess on its face to be a defence. Now, my learned friend says that this document says in terms that it is a defence because one can glean that from the first line. I disagree with that submission. Chief Justice, you asked my learned friend, where in this document does it say the word defence? And that document, that word does not appear anywhere. And we say that is significant because in contrast...
Yeah, but isn't it obvious from the memo that it was filed by a lay person?
Chief Justice, I'm afraid not. This was not filed by a lay person, and it bears emphasis that Mr. Sethi has been represented throughout these proceedings. We are not dealing here with a litigant in person without familiarity with the rules. Mr. Sethi instructed lawyers, and the reply memo, if one turns it up, is signed by his legal practitioners.
Oh.
So, and I do emphasize that
I didn't notice that. Where is the memo again? Sorry. It's under chronology.
It's at tab E, page 23, I believe. Page
23, is it? E23. E23. Okay. Zaid, advocates and consultant.
So I do, perhaps that is a convenient place to pause. And if I might be permitted to perhaps go sideways and look at what actually happened when this document was filed. And I apologise that this will involve some jumping around in the bundle. Sure. But if one goes to page N15.
N50.
15, Chief Justice, N15.
Yes. Yes.
Behind tab 2 of N, if you're working out of the same bundle that I am.
Yes.
This is the letter from my then instructing solicitors, Clyde and Co, serving the claim form and the document pack. And it sets out in very clear terms what's required in terms of compliance. Now, this was served on Mr. Sethi personally. He refused to accept service by courier, so it was also served on his legal practitioners. There is then, if one scrolls down then to page N16, just below, this is an email from Mr. Sethi's lawyers confirming that they acknowledge receipt of the claim documents and are representing Mr. Sethi. There is then
yes.
Apologise, I've just lost the reference to the document I wanted to take your lordships to. If one scrolls down to page N17, again, this is the email sent to the registry, which is the crux of the dispute on this appeal. This is the email saying, kindly find the attached reply memo. Again, describing the document as a reply memo. That's sent by Mr. Sethi's lawyers. And then the response from the registry is above that. Dear sirs, please ensure that you file all submissions online via the e-registry portal. I think it's worth just keeping those documents in mind as I take you through my submissions now on why we say that this didn't purport to be a defence. So yes, I do rely on the fact that
if Mr. Patrick Joyce was correct in his submission, then this registrar was wrong in concluding that you have to do it only through the e-registry portal. I mean, I'm just making a statement.
Well, Chief Justice, yes, and I'll come on to that in terms of filing. But actually, I do say that it's relevant also for this purpose, because for something to purport to be a defence, it has to be recognisable as such. And in my submission, the DRC Court registry here did not recognise the document as being a defence. They said, please ensure you file all submissions online via the e-registry portal. That's, of course, my emphasis, but the registry did not say, here's a defence. but it needs to be filed. Obviously, I'll come on to filing and we can deal with that separately. And as a matter of fact, the registry, when they received this email, it's clear from the record that they did not add that document to the court file on the case lines system, having made that request. And then again,
Can you help me? Oh, sorry. I'm slightly puzzled. Go back to N16, which is the lawyer for the defendant, saying we have acknowledged receipt of the claim documents to represent Mr. Sethi. That's on the 5th of August.
My lord, yeah.
That presumably got to the registry, because the registry, right on the 10th of August, the next page, saying please file submissions via the e-registry portal. What I'm puzzled about, sorry.
I don't believe so, my lord. I apologise for interrupting. I think this email was just sent to Clyde & Co. The email at N17 from the registry was in response to the email immediately below it of the 9th of August.
With the reply memo.
Which was attaching the reply memo, exactly.
I see. Thank you.
I don't believe, I'm sure my learned friend will correct me, but I don't believe the email of the 5th of August at N16 was copied to the registry. I'm afraid I don't speak Arabic, but I don't believe that those addresses would have reached the registry.
Right. I think you're right.
For completeness, and in any event, if my lord's concern was whether that was an acknowledgement of service, it was, of course, after the 3rd of August deadline, in any event. So I don't believe that either side places any reliance on that. Certainly for my purposes, I simply draw it to Your Honour's attention that Mr. Sethi was being legally represented throughout this period and advised. And so we say, clearly the document did not give the appearance of being a defence because the registry didn't recognise it as such. And neither did the judicial officer when he came to enter the default judgment. If that document had the appearance of being a defence, then of course a default judgment wouldn't have been entered.
In terms of the contents of the reply memo, does it lack anything of substance that is required by the rules to go into a defence?
My lord, we say it isn't the paragraph by paragraph response to the matters raised in the particulars of claim that one would expect under Part 16 as being a compliant defence. It also, as my learned friend has already raised, is accepted that there's no statement of truth, which is a matter of form, but an important matter of form. And of course, as I've already said, it is not signed by Mr. Sethi himself, but it's signed by his lawyers and it's signed respectfully submitted. And so we say it gives more the appearance of being a skeleton argument or a written submission than a defence per se.
I was looking, if I can interrupt, I was looking at the requirements of the rules for a content of defence at 1723 to 1732. And looking, I appreciate that it doesn't go, the reply memo doesn't go paragraph by paragraph, but I can't see anything specifically missing in terms of content when compared with the requirements in 1723 to 1732.
My lord, one could be formalistic about the requirements in 17.26 about which allegations are admitted or denied or put to proof. And again in 1727, stating reasons for denial of allegations. That is complied with in perhaps the most generic terms in the reply memo, but I accept that those are formalistic concerns rather than matters of deep substance.
And 1728 makes it clear that if you fail to deal with the allegations as you're meant to do, then you're taken to require that they prove those allegations.
Indeed, indeed.
May I have one comment, if you don't mind?
Of course.
My comment this memo, on the face of it, it's took a style of a memos submitted before a Dubai court. And we have here a Dubai court practitioner. Even from the title is missing a defense, but it's a memo reply, which is usually this is the style before the Dubai court, which means a defense in any way. Plus, if you can notice from the relief sought by the defendant, he is asking for dismiss the claim. Plus, he's asking, of course, for the court to appoint an expert. Now, regardless of the formality, might be the practitioner is luck with. He don't have that much of formality with the DIFC court, let's say, style of statement of defense. But in the merits of the document itself, it would give you the same result, isn't it? It will somehow reflect the attention of the defendant to file a defense. So he's saying in the beginning, this is a memo to the statement of claim, and in the end, he is asking the court to dismiss the claim. So why we have disregard all those things on this memo and stick with the formality of the title of the statement or the statement of truth signed by the claimant himself or his legal representative. I hope I made myself clear.
Thank you, Ajay. Yes, there are 3 points I think in response to that. The first is as to the title. Well, perhaps the first indeed is the point about it bearing the style of an onshore submission. Of course, whilst that may be true, Mr. Sethi's lawyers were registered DIFC practitioners. They were registered under Part 1 to practice here, and they must be taken to be familiar with the rules and procedures of this court and not simply the onshore courts. And in advising Mr. Sethi, clearly it's their duty to familiarise themselves with the rules and to get it right. That's a requirement of being a registered Part 1 practitioner. As to the point about their particular use of the word defence, we do say it's relevant that when Mr. Sethi's lawyers filed the application on the 20th of September, the document that was attached was clearly headed defence statement. And so although in his application, Mr. Sethi has pointed to the fact that English was not the first language of his lawyers, and as Your Honour has correctly identified, they are perhaps more familiar with the onshore practices, when the time came, we say, for them to articulate a defence, they called it a defence. That's the document that was relied on below, and it was clearly called defence statement. And so that brings me to my next point, which is that perhaps the most telling evidence that the reply memo did not purport to be a defence is that not even Mr. Sethi or his lawyers recognised it as such at the time. As I've just been submitting to Your Honours, at no time during the application did he rely on this document as being his defence. Rather, he filed an entirely new document entitled Defence Statement, and that was the document which formed the basis of the application. So it did not even purport to be a defence to Mr. Sethi and his own lawyers. And it's relevant also for this reason, which is that, of course, filing a defence statement, that was technically a new defence or an amended defence, which he had neither the consent of the respondent, my client, nor the court's permission to file and rely on, which would, of course, have been required under RDC 18.2 if the first document, the reply memo, had been the defence, or even purporting to be the defence, had been filed as such. And so we say again, had that point been taken, that would of course been, the respondent would have drawn that to the court's attention, that what we had on the 20th of September was therefore an amended defence, which required permission. And so we say that Mr. Sethi really can't have it both ways and say that at the time, nobody thought that this defence, nobody thought that this document was anything in the nature of a defence, and it was not relied on as such. It was not recognised as such by the registry, and it was not recognised as such by the judicial officer who entered the default judgment. But now that it suits him, suddenly the reply memo is the defence. And we say that's not what purports to be a defence means. And so we say that the reply memo was not a document purporting to be a defence, and that isn't just a matter of formality, but there are good reasons for that. Obviously, the default judgment is an administrative process, and one is entitled to be able to recognise whether the rule has or has not been complied with without the sort of detailed scrutiny that we're now engaged in. My Lord, did my Lord have a question?
The only things, if you can comment on how much regard you will give then to the fact that they are denying the claim. And they are asking the court to dismiss the claim and denying the statement of claim. So what?
Your Honour, in my submission, very little, because that sort of a statement could equally be contained in a skeleton argument or a written submission before the court. It would be expected that statements of that nature could be made even in correspondence, but particularly a skeleton argument. And indeed, the registry, when in its response, you'll recall, stated, please ensure you file all submissions online via the e-registry portal. So I don't agree with my learned friend's submission that just because the first line says that the claim is denied, that one can take from that this is a document purporting to be a defence. But that in any event, it's my primary submission that one shouldn't have to get that far. Even if it's not all bells and whistles compliant, it should be tolerably clear on the face of the document that this is being filed as a defence, even if it's not quite right. And we say that just isn't the case with the reply memo and wasn't intended to be the case. That's very clear from the way that Mr. Sethi conducted the application below. Your Honours, unless I can assist further on that point, I'd propose to move to the issue of filing. So we say on this point that even if the reply memo did purport to be a defence, that nevertheless it was not filed within the meaning of RDC 13.4. Now, obviously, it's accepted that it was not filed via the GIFC portal, but the position that's now argued is that essentially that emailing this document to the registry sufficed. Now, I've taken you to those documents, and it's N17, and then at the bottom of the page, and then at the top of the page for your Honour's note, that's the relevant email exchange. It was emailed to Clyde & Co and copied to the registry, and then the registry, of course, responded in terms, please ensure that you file all submissions online via the e-registry portal. Pausing there, I accept my learned friend's submissions that the RDC does not mandate e-filing absolutely in all cases, and that in some circumstances, emailing the court a document will be acceptable. But it did not follow that it was acceptable in this case, and one has to look closer at the rules. And they are those that were identified by the learned judge below in his order giving reasons, and my learned friend's taken you to some of them. RDC 16.5, dealing with the defence, states that a party may file a defence by submitting it electronically using the court's e-filing system. It does not give an alternative option there of simply emailing the document. Likewise, RDC 620 says that all documents should be submitted in an electronic form only, preferably through the e-filing facility, with an immaterial exception. And then, of course, RDC 6.21 states that e-filing should be used unless it's impossible in the circumstances. And I do emphasise that, because in my submission, that is an important proviso to the requirement to file at 13.4. One has to file a defence by the relevant time. And what does filing mean? It means that you use the e-filing facility unless it is impossible in the circumstances.
What do you say about part 2, the definition section of the rules?
My Lord, I accept that filing is perhaps the global term, and that within it there is e-filing and submitting electronically to the court. I accept that e-filing is simply a method of filing, but one has to look at what is said about the circumstances in which one e-files versus the circumstances in which one does other things. And RDC 6.21 is very clear. E-filing should be used unless it is impossible in the circumstances. And that's borne out by what happened in this case. I took your lordships to page N14, which was the letter sent by Clyde & Co. Enclosing the response pack of documents. In that letter, Clyde & Co. highlighted Rule 7.35 of the RDC, which says, please note that a form for defending the claim, and this is in the words of RDC 7.35, but it's here for convenience. A form for defending the claim, a form for admitting the claim, or a form for acknowledging the service of the claim must now be filed by you as the defendant of the claim using the DIFC Court's e-filing system within the time frame prescribed by the RDC. Then, of course, Mr. Sethi, his lawyers come on board. Mr. Sethi emailed, and it's slightly out of sync in the bundle, but it's at page R5. I apologise for jumping around within the documents, but at page R5, I think that's an incorrect reference. My lords, I apologise, that's an incorrect reference, and I'll dig it out. But Mr. Sethi emailed in particular procedures, so he acknowledges the relevance of the RDC rules. I will find a reference for that email for you. But then we see the email that I've taken you to at N16, which is the email attaching the memo to Clyde & Co. copied to the registry. Kindly find attached the reply memo. And then the response of the registry is to say, please ensure that you file online via the e-registry portal. Now, at that point, in my submission, if Mr. Sethi's lawyers wished to avail themselves of RDC 6.21, i.e. to argue that they came within that exception, that then it was incumbent upon them at that stage to explain why it was impossible in the circumstances, to use the language of RDC 6.21, to comply with not only the rules, but the registry's clear direction. And it bears emphasis that no explanation has ever been submitted in this case as to why that email from the DIFC Court registry was entirely ignored. It has never been said that it was impossible to comply in the circumstances with the direction from the registry. It's never been explained why the reply memo simply wasn't just filed in accordance with that direction and in accordance with the rules. And so we say that Mr. Sethi doesn't fall within the exception at RDC 6.21. It was not impossible in the circumstances because he hasn't established that. And therefore, in this case, in the circumstances of this case, filing meant e-filing.
Ms. Hurst, your argument, I think, involves treating the word should as being a mandatory directive, or whatever the right expression is. In other words, whereas it might be read as softer than that, strong encouragement, but not mandatory. And if one takes it literally, for example, it overrides what is said in the definition section in part 2, which means you can deliver a document by post. So are you saying that you can't deliver it, you can't file a document by post because this thing says it should be filed using the e-filing facility?
My lord, in my submission, one could file it by post if it was impossible in the circumstances. It's not unusual in a system of rules for filing with a court that there is a hierarchy of mechanisms, and it's not inconsistent with the definitions for there to be permitted methods of filing, post, email, and e-filing. but for further clarification within the rules to provide clearly in my submission that e-filing is the #1 option and must be done unless it's impossible in the circumstances. And then, of course, one has the option, one has rule RDC 6.20 saying all documents to be filed in the DIFC courts should be submitted to the court in electronic form. And in my submission, that has to be read together with the definitions, because notwithstanding that something can be posted, the rules still require an electronic copy to be filed, either using the e-filing facility or via email. So we say that the rules make clear that e-filing is the default, unless it's impossible in the circumstances. And pausing there, my lords, I would submit that that's entirely consistent with established practice in the DIFC, and that the registry is not accustomed to having litigants post documents or even to accepting submissions via email, but that strong encouragement is given by the registry, such as this email, where there is an instance of non-compliance, to direct litigants to use the correct procedure. And so in our submission, unless Mr. Sethi can establish that it was impossible in the circumstances to e-file this document, which he has not done so and has never sought to explain, then it was not open to him to simply treat this email as filing. Pausing there, I would reiterate that having sent this email, the registry did not add the document to the court file, and so at least from the registry's perspective, did not treat the document as having been filed.
Was the registry aware or brought to their minds that they could have, the documents could have been filed by email, which the appellant did, emailing the documents to the registry, which he did.
Chief Justice, so far as I'm aware, there was never a response to this email, and so this is the extent of the exchange. The email was sent and the registry responded in the terms that you see there.
Yeah, I know, but was
nothing
it right
further
for
was
the registry
said, as
to
far as I'm aware.
reject? Was it right for the registry to reject that?
Well,
Because
in my submission,
66.212, emailing the documents to the registry email account at registry@dif.co.ae, and that's what the appellant did.
in my submission, that would have been open to the appellant had he responded and said, it's impossible for me to do so. Dear registrar, I cannot use the e-filing system, the e-registry portal. This is the reason why. And then in that case, he would have taken himself out of the proviso in RDC 6.21. But that was never done. There's no explanation as to why this was completely ignored by Mr. Sethi and his lawyers. And so we say that there is a clear hierarchy, that is the way that the registry certainly interprets the rules and treats litigants, and that it is right and consistent with the rules for there to be a hierarchy, and that absent explanation as to why proper procedure could not be followed, proper procedure should have been followed, and it was not. It comes perhaps to a similar point, Your Honours, that I made in relation to purports to be a defence, but there are good reasons why strict filing should be insisted on, because obviously the requirement to file a defence is an essential step in compliance with the procedural timelines, and the claimant, in this case my client, is entitled to be certain whether or not the requirement has been complied with in view of the expressly mandatory nature of RDC 14.1. So the claimant has to be able to discern whether something has been filed, not least in terms of assessing whether the relevant deadlines have been met or not, and whether it's entitled to apply for a default judgment. And if filing means something short of appearing on the court file, then that becomes very difficult for the claimant, who has to sort of qualitatively assess whether or not this email exchange was sufficient. In circumstances where one logs onto the case line system and one accesses the case and all of the documents that are there on the court file, if I can use that colloquially, and there is no defence there. And in my submission, whilst there is some flexibility afforded to the defendant so that a document purporting to be a defence will be enough, there's absolutely no flexibility in RDC 13.4 that whatever document is said to articulate the defendant's defence must be on the court file by the specified deadline. And here we say it was not filed.
Well, isn't there a problem there with you said it must be on the court file, it must be on the court file, but that involves, in the case of emailing a document, it involves the registry doing the final step, whereas the rule says you file it by sending it, for example, by email if you can't send it another way. So the filing may happen even though it doesn't actually appear on the file.
Oh, my lord, in my submission, that's not right, because the court filed ought to mean on the court file, so that it is capable of being determined by court users, including the claimant and including the registry themselves. Now, of course, there may be a small gap of time in the registry receiving a document via email and uploading it onto the system. But what we're talking about in this case was a document being emailed on the 9th of August and it never then being treated as having been filed on the court file. No response to this email was ever received.
What I have in mind is that when you look again at the definition, the interpretation, filing means delivering it by post or otherwise to the registry. If the registry, for whatever reason, perfectly bona fide takes a view that that document should not be put on the file, it is nonetheless filed by the defendant. And there may be problems that then occur if you're looking to see whether a defence has been filed and you don't see it. And it may be that that is the situation in which you get default judgment, but a defendant can then come along later and say, hang on a minute, I filed my document by sending it, and if the registry didn't put it on the court file, that's not my fault.
Well, my lord, respectfully, I would disagree with that construction of the rules and say that filed must mean received by the registry and treated as the document that it is. Of course, any document could be posted to the registry, but there has to be a moment at which the registry opens that document, decides whether it is a document that is a defence or purporting to be a defence, and then does something with it. Otherwise, any document that had Mr. Sethi could come along and write a witness statement saying, I posted a document on this date, and therefore I filed a defence. And there would be no qualitative way for this court or the claimant or any litigant to assess whether that requirement had indeed been complied with. One has to be able to point to something as being an accurate record, and we say that that's the court file. Accepting that there will be a gap of time when the registry processes documents that are sent to it other than via the e-filing system, the court file should be determinative, and that any other construction would just lead to the sort of uncertainty that we see in this case, where one is not sure whether a document is a defence or not, and one is not sure whether it's been filed or not. And given, my lord, the mandatory nature of RDC 14.1, in my submission, that just simply isn't satisfactory. If there is such thing as mandatory set aside, it has to be clear whether those requirements have been satisfied without engaging in this sort of evaluative process.
Thank you.
Sorry,
Lord,
sorry to interrupt. Are you saying we don't have for fact whether this document was sent to the registry or wasn't sent to the registry? Because I get confused a little bit.
Your Honour, it was certainly sent, and it was certainly received insofar as we see the response email from the registry saying that it has to be e-filed. The further step that was not done was adding it to the court file.
Well, I understand, but we have for the fact it's been sent by the defendant and received by the DIFC court. The lack of whether this document was put in the file or wasn't put in the file, this is a matter issue. Another issue, and whether this document will be treated as a defense or not a defense, this is another issue as well. So as a matter of fact, the defendant has sent this document during after the claim was filed and before the before the judicial officer made his judgment. Now, maybe the judicial officer haven't seen this document. This is a separate matter as well. So, but I want to make sure my understanding is right. So you are acknowledged that was sent and received by the registry, but not filed in a proper way. This is your point of view.
Your Honour, yes, that's entirely right. I accept that a document was sent and received by the registry. I don't accept that it was a document purporting to be a defence, and I don't accept that it was filed on my construction of the relevant rules. Your Honour has my position entirely right.
Right.
Your Honours, I don't have anything further to say on filing, save that it's as to the issue of timing of filing, it somewhat bleeds into the next point which I'm going to address, which is this point about an acknowledgement of service. And in essence, the point is this: Your Honours have seen that there are two forms of default judgment that one can obtain: an acknowledgement in default of acknowledgement of service and an acknowledgement in default of defence. And when one looks at the rule for a judgment in default of acknowledgement of service, the wording says that there must have been no acknowledgement of service or defence filed by the relevant time. Now, we disagree with the construction of these rules that was put on by His Honour Justice Al-Madani, giving his reasons for permission to appeal. We disagree with the construction of the rules that is posited there, whereby the learned judge comments on the BankMed decision and determines that, notwithstanding the decision in BankMed, there is in fact no requirement to file an acknowledgement of service in the circumstances of the present case, i.e. where particulars of claim have been served with the claim form. But if I can put it another way, the construction that I contend for, and it's probably useful to set it out at the start, and then I'll give you the reasons why I say so. The construction that I contend for is that those requirements are not cumulative, but they are alternative, and that on a proper construction, one looks at the date by which an acknowledgement of service would be due, and if there is neither acknowledgement, if the defendant has failed to file an acknowledgement of service or has failed to file a defence by that date and not by the later date when a defence could be filed, then at that point in time, a claimant is entitled to apply for a judgment in default. And in my submission, when one applies that to the present case, what the rules require is that by the 3rd of August, the defendant had to file either an acknowledgement of service indicating that he intended to defend, or file a defence by that time, and he did neither. And so, in other words, the date of the 3rd of August, which was the date for acknowledging service, that date could not come and go without any document being filed. Now, the point was considered in BankMed, in the decision which Your Honours has already looked at briefly, in submissions of my learned friend, and it was determined there at paragraph 27 that the rules do not envisage any circumstances where a defence is to be filed without an acknowledgement of service. And again, at paragraph 30 of that decision, on the facts there, the Court of Appeal proposed a counterfactual that if there had been no, because in that case there had been an acknowledgement of service, but there was a query about whether it had been filed with authorisation. to do so. But so they posited a counterfactual saying that if there had been no authorised acknowledgement of service, then a judgment could have been entered in default of appearance following proper service of the claim form. And we say that's entirely orthodox. That has always been the accepted position, that a defendant must file an acknowledgement of service by the deadline or file their defence by that period. And it's only if they can't file a defence by that deadline that one files an acknowledgement of service, and that indicates that the defendant requires more time and is going to take the full amount of time allotted to file the defence. Now, the learned judge, obviously, in granting permission to appeal, did so on the basis that it was arguable that the conclusion of the Court of Appeal in Bank Med was incorrect. And he posits the alternative construction of the RDC that meant that the claimant was entitled to obtain judgment in default of acknowledgement of service only if the defendant did not file an acknowledgement of service by the 3rd of August, or a defence to the claim, or any part of the claim, by the 20th of August. In other words, the judge's construction is that those requirements are cumulative, and then one cannot have a judgment in default of acknowledgement of service unless there has also been a failure to file a defence. With all due respect to the learned judge, obviously there was no argument on that point before him in the permission to appeal application. And we say that that's wrong, and that the approach of the Court of Appeal in Bank Med was the correct one. Firstly, and most obviously, the rules clearly distinguish between a judgment in default of acknowledgement of service and a judgment in default of a defence. Now, if one looks at the facts of this case, the judge's construction would render that distinction completely otiose, because a judgment could not be obtained simply in default of acknowledgement of service on the facts of the present case. It would not be conceptually possible to do so. And that's an anomalous reading and goes counter to the plain wording of RDC 13.4. My Lord Glennie raised the point about 13.4 in questions to my learned friend. And we say that actually RDC 13.4 goes to show why there is a requirement to file an acknowledgement of service in any case, accepting the infelicities of the drafting of other rules, because on the wording of 13.4, when one looks at judgment in default of defence, one cannot get a judgment in default of filing a defence unless there has been an acknowledgement of service. But on the judge's construction, one could then get a judgment in default of acknowledgement of service without there being any requirement to file an acknowledgement of service at all. Now, we say that that's a construction of the rules that does more damage to their plain language than the construction arrived at in Bank Med, which, whilst there are infelicities with that construction where there is a gap, where there is no gap, I beg your pardon, between claim form and particulars of claim, that construction does less damage to the plain wording of RDC 13.4 than the construction which is contended for by the judge. And so we say that an acknowledgement of service ought to be required in all cases.
What do you make of 11.2, which says that a defendant shall file an acknowledgement of service in 3 particular cases, and therefore application not in other cases? But, sorry, doesn't have to in other cases. You may do under Rule 10.
My Lord, we say that the implication and doesn't have to in other cases doesn't follow when one takes into account RDC 11.4, which states the consequences of not filing an acknowledgement of service. That's set out at paragraph 37.
Sorry, it says it presupposes a case where you're meant to file one, because you fail to file it within the period specified. And that is clearly applicable to a case where acknowledgement of service has to be filed.
Well, RDC 11.5 is the general rule of a period of filing acknowledgement of service 14 days later. Then the consequences of not doing so is that... But
where's the obligation? And the general rule is that's about timing. You still need the obligation to file an acknowledgement of service, and 11.2 says that you don't have to if the claim form is served with particulars of claim and then unless later on you're unable to file a defence in time?
Well, my lord, it says that there is no. It does say that there is a requirement to file an acknowledgement of service if one is not going to be able to file a defence within the period. What it is ambiguous on is the question of, and what it has not explicitly catered for, as the learned judge acknowledged in his reasons for granting permission, is that there may be circumstances in which the date for filing an acknowledgement of service, if calculated, is the ordinary 14 days, and the date for filing a defence do not fall on the same day. And so the drafting of our 11.2 is predicated on what we say is an incorrect assumption that the defence will always be due on the same day as the acknowledgement of service. And so if one is not going to file by the date of the acknowledgement of service, then if one is not going to file a defence by that date, then it's necessary to file an acknowledgement of service to say that the defence is coming later. And so we say that the same logic applies in circumstances where, because of the particularities of service out of the jurisdiction and the period for filing a defence being extended, the same logic applies that one is obliged to file an acknowledgement of service if the defence is not going to come on the usual day on which one expects a document, either an acknowledgement of service or a defence, and that is 14 days in all cases. And so it's established practice that there's a 14-day period. If the defence is not going to come on day 14, one files an acknowledgement of service, and that effectively buys the time to take the full extent of the allowance that the RDC provides to file a defence, for a longer period to file a defence. And so whilst I accept that implicitly in RDC 11.2 it has not catered for the circumstance where there's a gap, I say the logic is the same. Where a defence can be filed within 14 days, it is to be filed. If it cannot, then an acknowledgement of service is due. And in our case, that was due on the 3rd of August. Now, my learned friend and I think, agree on this point, and perhaps your honours too, as well as the judge below, that these rules are not clear, and that no doubt amendments could be made to the RDC to make that clearer. But it certainly can't be denied that as a matter of established practice, it has always been assumed that an acknowledgement of service is required in all cases. And that was the conclusion of the Court of Appeal in Bankmed 2, that an acknowledgement of service was required in all cases.
I'm sorry, your submission contradicts that, because you said under 13.4 that if you can file your defence within 14 days, you should do so. But if you can't, then you file an acknowledgement of service. So it presupposes that you may file without an acknowledgement of service.
That's entirely right. And I apologise, that was inaccurately put on my part. An acknowledgement of service is required in all cases unless the defence can be filed within the period which would ordinarily be afforded for filing an acknowledgement of service, which in any case is 14 days.
But that submission is contrary to what the court said in the Bankmed case, which is that there can never be a case where defence is filed without acknowledgement of service. And I have to say, I don't myself think that is right when the court said that, but your submission seems to confirm that that's wrong.
Well, my lord, it's wrong in the limited case, and I say limited in terms of fact. There are very few cases where a defence can be filed within 14 days of receipt of the particulars of claim. Those cases do exist, but they are rare. But where particulars of claim are received and a defence can be filed within 14 days of receipt, then in such a case, in my submission, one would not need to file an acknowledgement of service, because the defence can be filed within the deadline within which one would otherwise file an acknowledgement of service. But in the vast majority of cases before these courts, as with the English courts and elsewhere, it is a very rare case where, in fact, a defence is filed within 14 days. And so the usual course is that one files the acknowledgement of service saying, yes, we've been served and we intend to defend. and then there is a further period within which a defence in a more complicated dispute can then be filed. So to that limited extent, I would accept that the premise of my submissions is that to that degree, the conclusion in BankMed is wrong, that there is a limited category of cases in which an acknowledgement of service is not required, and that's if the defence is capable of being filed within the period within which one would otherwise need to acknowledge service. Absent that category, receipt of claim form and particulars of claim, 14-day period, either one acknowledges service or one files a defence. If one does neither, then we're in default judgment territory. And so I come back to the point that I made as my overarching point, which is that really this is a point of timing. It's either one files an acknowledgement of service or one files a defence. But in any event, it has to be done by the earlier deadline. Something has to be filed within 14 days. And I say that the clearest support for that is in RDC 13.22. Excuse me, Your Honours. RDC 13.2 is set out in my skeleton, paragraph 37C, and it provides that on a request for default judgment, the court must be satisfied that subparagraph 1 isn't relevant. Subparagraph 2, either the defendant has not filed an acknowledgement of service or has not filed a defence, and that in either case the relevant period for doing so has expired. And so RDC 13.22 clearly contemplates a default judgment can be entered where there has been a failure to file an acknowledgement of service only, but something would have had to have been filed within the relevant period, which we say is 14 days in all cases.
Can I just, sorry to keep interrupting you.
Not at all, my lord.
Clear, I understand. Going back to 13.4, you say, I'm just trying to understand your submissions, you say in the ordinary case, 14 days for acknowledgement of service. You could serve a defence within the 14 days, and then you wouldn't have to serve acknowledgement of service. But if you left it to the 15th day, then serving a defence on day 15 would still allow you to apply for judgment in default of acknowledgement of service.
Quite so, my lord.
That doesn't make sense, because if acknowledgement of service was entered a day late, you couldn't apply for judgment once it had been entered.
My lord, in my submission, if an acknowledgement of service nor a defence has been filed on day 14, then on day 15, one is entitled to judgment in default of acknowledgement of service.
I expressed my question badly. Let's say 14 days, neither acknowledgement of service or defence. But on day 20, just to make it clearer, day 20, a defence is served, but no acknowledgement of service. Actually, sorry, I'll take it back. Day 20, acknowledgement of service is entered, filed. Yep. And on day 30, you can't then apply for default judgment, because even though the acknowledgement of service was late, because it has been served by the time you apply. Yep.
Quite, because the requirement in RDC 13.4 is contingent on that being filed by the date of the application and not by day 14, if I can put it that way.
Surely, therefore, if on day 20, instead of filing acknowledgement of service, he serves a defence and files a defence, you're saying in that situation you can effectively ignore the defence and go for judgment in default of appearance. In
default of acknowledging service, because that deadline would.
So 10 days after he served a defence, you can still apply for judgment in default of acknowledgement of service. Is that really your submission?
I'm sorry, my lord. Can you?
Day 30, he applies for judgment in default of acknowledgement of service. The defendant hasn't acknowledged service, but has entered a defence on day 20. So before you apply, but after the time limited for acknowledgement of service. And you say you can effectively ignore the defence that he's put in and apply to the court for judgment, default judgment, in default of acknowledgement of service, even though he served a defence a few days late?
Yes, because the relevant time, where the rule refers to the relevant time for doing so, those requirements are alternative. So the relevant time for filing the acknowledgement of service has been filed, and it makes sense, my lord, if one takes 13.4 and 13.5 separately. One is addressing the failure to file an acknowledgement of service. One is addressing the failure to file a defence. They are both requirements. They are both circumstances in which a default judgment can be entered. And where in 13.4, subparagraph 2, the relevant time for doing so has expired, in my submission, the only way that the distinction between the two can be made sense of is if that is construed as the relevant time for filing an acknowledgement of service being 14 days, because otherwise one could not get a judgment in default of a defence being filed. Excuse me, a judgment in default of acknowledgement of service being filed. In the circumstances your lordship describes, there would then be no relevant sanction for failing to file any document by the 14-day period. And that is, as the judge below acknowledged, that is the settled construction of the identically worded provisions in the English CPR, whereby it is acknowledged and standard practice, and there are numerous examples in the authorities, that a judgment in default of acknowledgement of service is obtainable on day 15 when no document is filed. One does not have to wait and see whether something else is coming from the defendant, because by that point they have missed a deadline.
I've understood that. Sorry, I've understood that, but the different. My point was a different one, which was not having to wait and see, but if by the time you act, day 30, if by day 30 they have not served an acknowledgement of service, but they've served a defence, it seems to me that they have prevented you making the application under 13.4 in those circumstances, because already there is in existence a defence on file, even though they haven't acknowledged service. But anyway, I think you have my point, and I don't want to take up time.
No, my lord, I understand the point. In my submission, one would still be entitled to a judgment in default of acknowledgement of service because the defence had not been filed by the 14-day period. There is a gap on the file where nothing was done. And that's the only way that 13.4 gives sanction to the acknowledgement, to the obligation to file something within a 14-day period, which we say is the better construction of 11.2 taken with 11.4. Once one accepts that there is an obligation to file something by the 14-day period, if I can put it that way, then it follows that a judgment in default of acknowledgement of service can be obtained on day 15. If an acknowledgement of service is then filed, but a defence is not, then of course one is then in the territory of RDC 13.5. I apologise, Your Honours, my connection cut out just then. I hope I'm still with you.
Yes, you are. Can
you hear me? Oh, good. That's a relief. My screen went very blank for a second. It was somewhat concerning. Your Honours, that's all I propose to say on filing. There is the final point, which I said to you that I would park at the start of this hearing, which is the question of success on the merits. You have my primary point that we say that no permission to appeal was granted in respect of usurious interest. So I don't propose to repeat that, but let me address you, if I may, briefly on why we say, even if Your Lordship, Your Honours are willing to entertain it, that it's simply a non-starter. It bears emphasis, of course, that this was one of the defences that was fully canvassed before the learned judge in the hearing below. I showed you the order with reasons at the start of the hearing, that this is a very simple loan agreement governed by DIFC law and obviously with the jurisdiction of the DIFC courts, and Mr. Sethi has accepted at all times that DIFC law does apply to the loan. Simply put, We say that the argument that the contract cannot be enforced because of obscene usury, I think is the phrase used in the defence statement, is simply a non-starter. The law of usury does not apply to contracts governed by DIFC law. It is well established that a contract governed by DIFC law may provide for interest to be chargeable. That's set out, and I apologise, Your Honours, I see that the law has not made its way into the bundle, and I'm happy to provide a copy of it. But for Your Honours' note, Article 17 and 18 of the Law of Damages and Remedies, Law number 7 of 2005, clearly contemplates interest for failure to pay money. It sets out there, and I'll read so that it's in the transcript, and I'll follow up with a copy of the law. If a party does not pay a sum of money when it falls due, the aggrieved party is entitled to interest upon that sum from the time when payment is due to the time of payment, whether or not the non-payment is excused. And the default that's given in the remedies law is that the rate of interest shall be the average bank short-term lending rate to prime borrowers prevailing for the currency of payment to the place of payment. The remedies law also provides for interest on damages to be awarded by the court. And under the law of obligations, the court is, under the DIFC contract law, I beg Your Honour's pardon, the court itself routinely awards what one might call judgment interest under Articles 118 to 119 of the DIFC contract law. So it's not an exaggeration to say that interest is wholly ordinary and usual as a matter of DIFC contract law, and that is the law that is admitted to govern the dispute between the parties. And so as far as the penal code of the UAE applies, is relied upon by my learned friend, it simply has no application to a contract governed by DIFC law, which clearly envisages that the charging of interest is lawful. This point was taken by Mr. Sethi in the court below, and it was dealt with by the learned judge in his judgment. That's at tab W, the order with reasons from the set-aside application. If one looks at paragraph 39, which is page under a heading Defence 3, it's page W9. And here the learned judge sets out what was advanced below about usurious interest, usury being forbidden according to Sharia, etc., etc., and the submissions and response. And then at paragraph 41 on page W10, the judge said as follows: Mr. Sethi's defence in respect to the loan period interest and the default interest relies on UAE law. Mr. Sethi did not explain, however, the route by which UAE law applies in the DIFC. And it was found elsewhere that the law governing was DIFC law. And then paragraph 42, in any event, Mr. Sethi clearly agreed to the interest rates and made partial payments towards them. That was one of the defences advanced below, and that has not been taken on this appeal, that Mr. Sethi said that the claimants had failed to take account of payments that he had made in respect of the loan. And in the court below, it was shown that those payments had been taken into account, and that when one looked at the underlying documents, they were said to be repayments of interest. And so the interest rate had clearly been accepted and complied with. We say,
yeah, go on. What was the prevailing rate at that time? Would you remember? Would you know? Because when you say usurious, and the word used was what was used just now? Obscene rate, 35%, 36%. What was the prevailing market rate at that time? Because that's important.
Chief Justice, I'm not sure I do know the answer to that. The rate under the contract was 24%. As I outlined at the start of my submissions, this was a short-term loan from a period of July to September, what one might term as a bridging loan. And so obviously the per annum interest rate is somewhat distorted in a contract of that nature. But in any event, even if we accept for present purposes that is a high rate of interest, it's a prevailing provision of DIFC contract law that the parties have freedom of contract and that they can contract for whatever rate of interest that they see fit. And the principle of Sharia, of usury, just simply has no application to a contract that's governed by DIFC law. It just doesn't bite. And as I say, all of these arguments were canvassed in front of the judge, and he rejected them. Yes. And your Honours have my submission that, having looked at them again, in considering the application for permission, they certainly didn't trouble the learned judge the second time around.
Can I just ask two very precise questions? First of all, you've addressed us on the rates of interest. What about the question of compound interest? Is that allowed under DIFC law? Is there any provision for it?
My Lord, I'm not aware of a provision that expressly states that compound interest is permissible, but certainly I would say it was caught by the general provisions which say that a party may charge interest, and is caught by the general provision of freedom of contract. It's of note that, of course, the DIFC contract law fairly closely follows English law, where compound interest is acceptable under the general principle of freedom of contract. Fundamentally, if that is the bargain that the parties have struck, that is the bargain that the court will enforce, subject to other possible routes and defences, which under DIFC contract law, of course, but not, in my submission, subject to any defence based on principles of Sharia. That simply has no application in the DIFC contract law.
That was my other question. Is there any DIFC authority decided case saying that in case of a dispute about interest or compound interest, that Sharia law or criminal law of Dubai has no application in the DIFC?
My Lord, I'm not aware of a specific authority on the point about interest. There are cases saying that the UAE federal law does not apply where there is where the dispute is governed by DIFC law. Perhaps if I can take a moment to find a reference, perhaps when my learned friend is giving submissions in reply, I'd be happy to do that. But my Lords, finally, that on this point, it bears emphasis that this is one narrow defence that has been selected out of a raft of completely unmeritorious arguments that were put in the court below as to why Mr. Sethi was said to have a real prospect of successfully defending the claim. And you will have seen the order with reasons at tab W that goes very carefully through the arguments that were advanced and rejected all of them. And it bears emphasis that there is no live appeal against the learned judge's finding that at least the capital of the loan is due. The learned judge went through all of the attempted defences that had been advanced by Mr. Sethi and rejected all of them, having considered them in detail, on the facts advanced as well as in law. In bringing his application for permission to appeal, Mr. Sethi quite rightly didn't dispute the judge's finding that he had no real prospect of successfully defending the claim on the substantive debt, on the basis of the various allegations that were said to amount to set-off, which occupied much of the court's time at the hearing below. And the only argument that was made was this argument about usurious interest. And as I say, due deference should be given to the learned judge who heard that application and who heard at first instance and then gave his reasons for granting permission to appeal. And I do say it's significant that he did not even entertain the defence that had been advanced on the basis of usurious interest. It is clear from the tenor of the judge's judgment that the learned judge had formed the view that Mr. Sethi was a recalcitrant defendant who was coming up with any possible argument to evade the claim. In fact, he found that Mr. Sethi had willfully ignored the court's proceedings. I've set out in my skeleton argument that unfortunately this is not the only instance in which Mr. Sethi has come up with elaborate arguments to try and avoid the consequences of his obligations. My clients are currently suing Mr. Sethi in proceedings onshore as well as in the courts of England, where they have obtained a default judgment, and Mr. Sethi, a summary judgment. Mr. Sethi hasn't paid any sums due under any of those agreements. And so we do say that unfortunately, this appeal has the tenor of a delaying tactic rather than any seriously advanced claim on the merits. And the reason I say that is because even were your lordships to accede to Mr. Sethi's appeal on ground 1, there is no appeal, or at least any appeal with any reasonable prospects of success on the basis of ground 2. And so Mr. Sethi is faced with a judgment that has rejected all of the arguments that he has ever put forward as to why the loan was not payable, and concluded that they have no real prospect of success. And so my learned friend's contention is that he can now apply to amend and put in a new defence. But of course, we've not seen that defence. We don't know what would be advanced within it. But if it's any of the same stuff that has already been canvassed before this court, then of course he faces an issue at Stoppel that those defences are simply not arguable. And so we are unsure as to quite why this application is made in circumstances where even if the default judgment is set aside, it would be open to my clients immediately to apply for summary judgment or immediate judgment, if not default judgment, on the basis that there is no arguable defence. And so in my submission, it is important that Your Honours have the tenor of the dispute and see the appeal for what it is, that whilst arguing over the very technical procedural niceties of whether the defence has been filed, there is a backdrop to this dispute of a serial defaulter who is coming up with any and every excuse to evade paying what was owing since September 2019. Finally, on that point, my lords, the final point that I would make on that is that in between the judgment below and the application for permission to appeal, my clients were able to commence enforcement proceedings. And in the course of those enforcement proceedings, Mr. Sethi has admitted that the sums are owing, and has offered and made an offer that was not formalised to pay it in instalments. And so he effectively contradicts himself now in these proceedings by seeking to argue a defence on the merits, which one assumes he does not believe in, because he has made contrary representations to the onshore Dubai courts. And so I say that all of that said, Your Honours are entitled to take a step back and look at what's really going on with this appeal, and whether, if one sets aside the default judgment on the basis of a technicality on filing, which in my submission in any event was not an argument that was open to him to raise on this appeal, and isn't correct on its merits, even if Your Honours aren't with me on that, it would be a Pyrrhic victory, and one that would very quickly proceed to an immediate judgment in any event.
Okay.
Your Honours, unless I can assist you further, those are my submissions in response.
Okay. Thank you very much. Thank you very much, Mr. Mr. Patrick Joyce, anything to say?
Well, Your Honours, I begin by reminding myself that it is not the purpose of a reply to repeat that which has already been clearly submitted, either
Of course.
and therefore I would invite the court, as I've previously invited, to read the submissions that I have made, as well as bear in mind the oral submissions, because those answer many of the points that my learned friend has placed before this court, and I also would respectfully adopt many of the interventions by the court in the course of my learned friend's argument. Again, I don't repeat those matters. My learned friend has made not just an intricate argument but an argument which involves rewriting straightforward wording of the rules of the DIFC court, both as to filing and as to conditions to be satisfied in relation to entering a default judgment. Much of what she said depends on form and not substance, and as a matter of general impression, it cannot be as complicated as appears to be the case. One will almost need a PhD in DIFC procedural law in order to navigate around the rules in order to satisfy the requirements that my learned friend has placed before the court. She opened by making two overarching points. Her first point was to argue that ground one was not open to the appellant. Ground one depends on the mandatory provisions of the rules of the DIFC court, and also, as was made clear in the course of argument, the application to set aside was expressly and originally made both on the basis of rules 14.1 and 14.2, and reliance was placed on the reply memo in that context. That, in my submission, disposes of my learned friend's first point. The learned friend then says that in relation to ground two, permission to appeal was not granted on this point. The first point is the operative part of the order, which is to be found at pages J1 and J2. But in our submission, in my submission, the learned friend fails to understand and appreciate the way in which granting the application under Rule 14.1 as a matter of mandatory setting aside of this default judgment would work. Because once the default judgment has been set aside, then matters can and should properly be ventilated in a properly formulated amended defence. And that is exactly what would be intended to take place. So the reason why His Excellency Judge Ali Al-Madani did not refer to the matters in relation to 14.2 and usurious interest and other matters is because on a mandatory application of the rules and the default judgment being set aside, it goes. There is, my learned friend referred to the procedural history. There is, of course, an updated chronology. That's at pages ZZ16 to 17, pages 26 to 27 of the bundle, if that is of assistance to the court. My learned friend's submissions in Damac and Ward, she correctly took the court to paragraph 66, which referred to matters of pure law. Here we are dealing with matters arising fairly and squarely from the rules of the DIFC courts. In my submission, there was an element of unreality about the elaborate dance that my learned friend engaged in to avoid the simplicity of what those rules say, both in relation to filing and purporting to be a defence. I think I can pass on now to a point which I found particularly troublesome, which was when my learned friend made submissions in response to my submissions, and she started off, she said there were 3 points in response, and the first point was a matter of style. She articulated the submission by saying that, in fact, it was a response to a point raised by His Excellency Judge Shamlan in the course of argument, who said that the appearance of the reply memorandum was very similar to what one would expect to find in onshore Dubai courts. she accepted that it might be similar to an onshore submission. She said that may be true. She went on to say that Mr. Sethi's then lawyers were registered in the DIFC, they were indeed, and she then submitted that therefore they should be taken to be familiar with this court. They should, in her words, familiarise themselves and get it right. Your Honours, the DIFC courts are an international commercial court, and although rooted in the common law jurisdiction, they do attract advocates and legal representation which is not from common law origins. There are legitimate, reasonable differences between the common law and the civil law. And in my submission, it is expressly to take account of such differences that one sees why RDC Part 13.2 is expressed in the way that it is, a document purporting to be a defence. Really, the court should be aware of what in my submission is a deliberate intention on the part of the drafters to introduce a measure of flexibility, given that the DIFC courts form part of the international commercial courts around the globe. I think that I can now pass on to some final submissions. My learned friend referred to Articles 17 and 18 of the Law of Damages and Remedies, Law Number 5 of 2005. I'll be corrected if I'm wrong, but I don't think that submission was even in her written argument, let alone that law failed to find its way into the authorities bundle. But it matters not. I accept that in the DIFC, the courts have an entitlement to grant and order interest. Interest, yes, but the statutory limit on that interest is 9%. And in the prevailing environment, which prevailed in 2019 and has continued ever since, it is a matter for judicial notice and a notorious fact that interest rates are very low, and even the 9% statutory maximum is excessive in my submission. But we are not dealing with 9%. We are dealing with 24% and 36%, which in my submission clearly is excessive and usurious. There is provision for compounding, as His Excellency Judge Lord Glennie pointed out. And finally, Judge Lord Glennie asked whether there was any DIFC authority saying that in the case of a dispute regarding interest, Sharia or criminal law had no application. There is one UAE public policy. There isn't a separate public policy in the DIFC, and it is UAE public policy that Sharia compliance is required. And there is plain authority for the UAE criminal law applying in the DIFC. That is a matter within the Constitution. I think it's Articles 121, possibly 122. But more importantly, if one goes back to the founding laws of the DIFC, it is the UAE civil and commercial laws which do not run in the DIFC. The UAE criminal law does. The DIFC has no criminal law. The only criminal law in the DIFC is that of the UAE federal law or the Dubai Emirates law. Your Honours, unless I can assist you further, those are my submissions in reply.
Okay, I don't think we have any questions. Do you any questions from Judge Shamlan? Judge Glennie, you any questions?
I don't have any, thank you.
Okay, so thank you very much, Council. Thank you very much for your very good submissions, and thank you very much for everybody and the registry and the IT team. I think we have to reserve our judgment. We'll come back to you when we're ready with the judgment. So thank you very much to both counsel.
Your Honours, thank you, and I'm sure I speak on behalf of my learned friend as well in thanking the court for the conduct of the whole appeal. Thank you indeed.
Thank you.